issues have come up this particular year with regards to cybercrime. What is cybercrime? Does it just involve assets? Does it involve hate speech? Does it involve spread of false news? These are issues we expect will be discussed in this paper. And luckily for us, we have a very, very erudite person to chair the occasion. Our chairman is no other person than Senator Yakubu Oseni. Let's give him a round of applause. He is also the chairman committee on ICT. So he is ably qualified to steer the ship on this particular topic. Also, we have our lead speaker one on the issue of cybercrime joining us virtually via the Zoom platform, who is Benedict Daudu. Benedict, can you hear me? Benedict Daudu, can you hear me? Okay, I understand that he will join us later. So Benedict is the one to give us the first paper. And we have the lead presenter two here, who is a familiar face. She has been with us throughout the entire course of this. She's an integral member of the Rule of Law Development Family, who is no other person than Chinelo Ogbozo.
Yeah.
I'm
online. I'm seeing that.
Also, I particularly recognize in our midst one of our lead presenters from the earlier session, Mr. DC Ewelum, Senior Advocate of Nigeria. Thank you for being with us and staying back. We must appreciate you for doing that. We also have, I forgot to mention that Chinelo Ogbozo will be dealing with management of confiscated proceeds of crime. How do we manage confiscated proceeds of crime? And I don't know whether her paper also touches on proceeds of crime online. We'll see and wait to hear what she comes up with. We have panelists here to discuss the various papers. We have Adedayo Kayode, who is a Director, Assets Tracing, Recovery and Management of the ICPC. So let's give him a round of applause. He's seated to the left of the chairman. So we have the prosecutorial agencies to also help us shed some light on this topic. Okay. I understand that Benedict Daudu is online. Benedict, can you confirm if you are here? Benedict Daudu, our first presenter.
Yes, I can. Can you hear me?
Yes, I can hear you. Thank you very much. Okay, let's give him a round of applause. He will be our lead presenter one. And we have the representative of Professor UG Dambata, who is the CEO of the Nigerian Communications Commission. And his name is Abang Lawrence Abwa. Let's give him a round of applause. He will also be shedding light on this topic. And we have also introduced an additional interventionist in the person of Honorable Chris Balogun, who will also be discussing the paper on cybercrime. Let us give him a round of applause. So, Chairman, you have your panel. I hand over proceedings to you. Thank you.
Thank you very much, Mr. Paul. Good afternoon, everybody. Mr. Kayode and Chinelo and other panelist member. Before we start the paper presentation, I would like to have a very brief remark. And this law weeks is something that has been coming, and this particular topic, we all know what is happening around the world today in terms of cyber security and all that. So it is a very important topic that we all have to deal with decisively. It is regrettably that criminal elements around the world have chosen to turn the ICT revolution into a nightmare. The gain of technology are being dampened by rapid and increased threats to digital domain. The current rise in cybercrime has become more dramatic and sophisticated, launching of attacks on governments, defense infrastructure, businesses, educational establishments, etc. Indeed, the invasion of cyberspace has come with grave consequences and is already costing the world huge losses in trillions of dollars and is posing serious danger to life. Oversight findings of the Senate Committee on ICT and Cybercrime have revealed not only the cybersecurity threat landscape, but also weak systems in Nigeria. There is a serious lag in infrastructure, data management, and digital security and know-how, which are critical to the development agenda. Our economy is already suffering hugely from cyber-related crimes, though most of these attacks go unreported for fear of anxiety and apprehension. Fresh experiences arising from the COVID-19 pandemic have further exposed stunning gaps in our digital and cyber ecosystem, and a wider yearning for accelerated mitigation efforts, which is why we're here today. It is therefore evident that all stakeholders should have their hands on deck to protect our dear country from this increasingly rapaging menace. The third annual Criminal Law Review Conference is a step in the right direction indeed. This session, which reviewed judicial updates and developments in cybercrime laws and management of confiscated proceeds of crime, is consequently very welcome. As you think, accordingly, processes to amend the law to fill the gaps are ongoing. We are all therefore urged to work together to mitigate cyber criminality and all other forms of crime in our society. As the Committee of the Senate saddled with matters of digital technology and cybersecurity, we are leaving no stone unturned. It is expected that this panel will adequately look at the subject matter with a view to finding solutions to filling existing gaps. While we allow the first paper presenter to discuss, then we'll deal with the arise from the paper presentation accordingly. Thanks you and God bless. I don't know whether Mr. Benedict Dabu is there. If he's there.
Thank you very much, Mr. Chairman.
You're welcome.
Okay. Thank you very much, Mr.
You
Chairman.
have just like 5 minutes to make your presentation. Oh, okay, 10 minutes. I'm giving you 10 minutes for you to just give us the synopsis of your presentation. Thank you.
So good afternoon, everyone. Conferees both online and at the Secretariat. I will be speaking towards legislative developments in cybercrime. I hope I'm audible, please. Yes. Okay. With cybercrime now a growing concern amongst countries both developing and developed, there has been a scramble by the legislature to properly provide laws that accurately combat cybercrime. And there are key questions that we need to address. One of which is this an ever-losing battle as a result of the constant and rapid metamorphosis of the cyber world? Is there a skill gap between cyber criminals, law enforcement, and the judiciary that poses a significant challenge, especially for cross-border enforcement? And in addition, is there a need for us to actually create specialized courts, such as the cybercrime court, that would specifically handle issues relating to internet law? I am hoping that within the course of my presentation, those online and over there can actually lend their voices by at least including their comments in the chat. Now, the internet has become one of the greatest technological developments in the world. While widely accepted for its ease and efficiency, it is ebbed with a multitude of vulnerabilities, which pose significant security threats to users and has led to the emergence of cybercrime. In Nigeria, cybercrime range from a vast amount of things. It could be bank verification number scams, it could be fraudulent emails, hacking, cyber harassment, social media hijacking, etc. But the core factor is that the high rate of unemployment, the quest for wealth, and a lack of strong cybercrime laws, as well as inadequate security on our personal devices, have all amalgamated to make cybercrime a significant problem for the country. Now, in the early hours, on the international standpoint, early hours of Saturday, June 27, 2020, the Federal Bureau of Investigation declared in a tweet that 6 Nigerians were wanted for their involvement in a business compromise scheme, and they defrauded about 70 businesses in the United States, which resulted in the loss of $6 million. Coincidentally, a few days later, the Dubai police apprehended Ramoni Balode, better known as Hush Puppy, where his syndicates were responsible for transfer of bank details and various accounts, hacking of various accounts of various companies in the United States and in Dubai. And this amounted to a loss of 1.6 billion dirhams, roughly the estimate of 168 billion naira. Now, from a grand scheme, this shows the impact that cybercrime has, not only in social purview, but also in terms of figures. The year 2020 brought with it several undetermined and unclear legal anomalies. Nigeria, as a country with diverse laws, was not left out of the debacle. You could pitch the blame on the global pandemic and SARS, but you will not be found wanting if you did so. Now, cybercrime as a legal concept showed us that there were several anomalies that need to be dealt with. On the 17th of October 2020, the Nigerian Army announced that it would commence a nationwide exercise dubbed Operation Crocodile Smile. This exercise was deemed to have a cyber warfare element to identify, track, and counter negative propaganda on social media. Generally, one would think that the Nigerian Army is constitutionally known to protect the sovereignty of Nigeria, both internally and externally. However, the announcement of such an activity brings to question what the implications of cybercrime are, especially to the detriment of the integrity and sovereignty of the Federal Republic of Nigeria. In the same vein, the aftermath of NSAS protests has seen several government officials calling for a bill to regulate social media activities, especially content that appears to affect the territorial integrity of the Federal Republic of Nigeria. These are many issues will be discussed throughout my paper, but I would like to at least give a brief definition of cybercrime, as I know there are certainly some conferees who are just joining us. In the narrow sense, Cybercrime can be defined in two aspects. There is the narrow and the broad sense of it. The narrow sense deals with illegal behavior directed by means of electronic operations that target the security of computer systems and data processed by them. Now, in the broad sense, it deals with illegal behaviors committed by means or in relation to a computer system or network, including such crimes as illegal possession, offering or distributing information that are associated with computer systems. For example, those who engage in child pornography and the distribution of child pornography would find themselves entrapped by cybercrime. Now, because of the lack of time, I shall dive straight into the recent reforms and developments on cybercrime. The Cybercrime Act has aided in the prosecution of cyber criminals without a shadow of doubt. However, the question I still ask as to whether its effectiveness is seen, especially in light of constant cybercrimes that are perpetrated around the country. Certainly several groups have called for the repeal or reenactment of the Act. There's a need to constantly develop the Act regulating cybersecurity, and this cannot be understated, so as to create a level ground to fight cybercrime. Now, a recent development is the National Information Technology Development Agency, NITSDA. It released the Nigerian Data Protection Regulation 2019, and thus far, it is the most comprehensive data protection regulation in Nigeria. The regulation applies to all transactions for the processing of personal data and the actual processing of personal data in respect to natural and those residing abroad. It is complementary to the Cybercrime Act 2015, and one sure way of combating cybercrime is by apportioning effective and proportionate and commensurate punishment for offenders, those who go against the provisions of regulation. The NDPR imposes both civil and administrative sanctions on violators and offenders. Now, I move on to another development in the cybercrime law. Especially this stems from a recent settled Court of Appeal judgment in the case of Solomon Okedara, an Attorney General of Federation. This was because where an appeal arose from the Federal High Court challenging the constitutionality of Section 24(1) of the Cybercrime Act with regard to the freedom of expression and fair hearing as enshrined under Section 36 and Section 39 of the 1999 Constitution. However, the Court of Appeal, affirming the judgment of Justice Buba of the Federal High Court, disagreed with the appellant that the provision was vague and overbroad and ambiguous and threatened his freedom of expression. However, a large deference goes to the ECOWAS Court by way of a viable departure from the above-mentioned decision. In this case, the Laws and Rights Awareness Society took up the Federal Republic of Nigeria and deemed that the Nigerian government and the judgment of that ECOWAS court deemed that the Nigerian government was liable for violations of rights of freedom of expression. Whilst delivering his judgment on the 10th of July 2020, in the words of the learned judges of the ECOWAS court, I read, "The provisions of Section 24 of the law in question typifies criminal conduct and defines the applicable sanctions. For this reason, in all ramifications, it must be legally well written and its elements clearly defined to avoid ambiguity in their meaning. For the exposed above, it can be concluded that when a law does not define the parameters of an element of a crime that it typifies, it cannot pass the test of legality, since by its nature it will be arbitrary. The defendant states by adopting the provisions of Section 24 of Cybercrime Act, violated Articles 9 of the African Charter, as well as 19 of the International Convention on Civil and Political Rights. In this decision, we see that the ECOWAS Court has placed the Nigerian lawmakers to live up to their billing and act in line with the current legal and social realities. Laws are made for all and not for a few. Thus, when certain individuals begin to see the law as an instrument to prevent others from exercising their fundamental rights, it behooves the legislature to reform such a law in a bid to prevent injustice. It is equally important at this juncture to say that one part of the lawmakers or legislature should, as a matter of genuine concern, be clearly defined and ascertained so that the piece of legislation can accurately ascertain its violation thereof. Now, furthermore, it will be out of place to point that and refer back to Operation Crocodile Smile. The Nigerian Army said that its aim was to combat cyber warfare and exercise designed to identify, track, and counter negative propaganda. In social media and especially in social media and across the cyberspace, whilst including positive identification components aimed at identifying Boko Haram terrorists fleeing, one would be surprised to see that the only outcome of this was the arrest of a soldier of the Nigerian Army who was appearing incognito with a mask on his face, who was simply appealing to the members of the Nigerian Army not to shoot peaceful protesters. This brings the question of an understanding of the Nigerian Army's notion of cyber warfare. Now, on the international or global front, several reforms to cybercrime have occurred. The European Union published in its official journal on June 7, 2019, the European Cybercrime Act. There was a growing need for effective coordinated responses and crisis management at the EU level. Hence, the need for the ECA. The ECA aims to build a safer cyber environment through an EU-wide framework for business to achieve cybersecurity certification for their information technology and products, process, and services. Now, since there are other elements to cybercrime, I would like to discuss the management of the confiscated proceeds of cybercrime. It is accurate to state that the general endgame of cybercrime, in its traditional sense, is to generate profit. This profit can be searched for and properly confiscated. However, technological advancements allow organized cyber criminals to commit offenses from anywhere in the world. Said profits in most cases are laundered online or held in different forms, such as Bitcoin. Furthermore, the evidence of these proceeds are encased in computers or storage devices. Now, there are various stages of confiscation of proceeds of cybercrime. There's the investigation stage, the judicial stage, and the disposal stage. But one can argue that we only have the disposal stage. The investigation stage is where a financial investigation is held. Proceeds of crime are identified, located, and evidence is collected. Then the judicial stage is where the defendant is convicted or found not guilty, and a decision on the confiscation is made final. The disposal stage is where the property is actually confiscated and disposed of by the state within the local law. One must bear the question that how often do our executive and policing bodies follow these stages? Now, in conclusion, cybercrime laws are meant to provide rules of conduct and acceptable principles for the use of the computer and all regulated digital technologies. In the same vein, the cybercrime law should adequately cater for rules of evidence and criminal procedure regulations in the cyberspace, so as to curb or mitigate the harm done to individuals, private organizations, government bodies, and other bodies. Now, for this topic so far, it behooves on the legislation to see that the responsibilities are expected of them from the judiciary, internal bodies, from the executive, and from the entire citizens of the Federal Republic of Nigeria, to not only make cybercrime laws that will be beneficial to a few, but to also pass cybercrime legislation that can successfully measure up to the genuine demands of the approval of all. Thank you very much, ladies and gentlemen, for listening to my presentation. I hope it was very informative.
Thank you so much, Mr. Benedict Audu. You see, when I said 5 minutes and we shouted that 5 minutes is too small, and I gave you 10 minutes, knowing fully that you might not be able to finish within the 10 minutes, and you've proved us right that you are actually a good summarizer, and all the message has been adequately passed to us. Thank you so much. We really appreciate you for that very erudite presentation. And
thank you, Mr. Chairman.
For the sake of time, I would like us to, you still remain, don't go away, to take the second paper. Then we can now ask our question together. We can take our question together. So stay there, don't go away. We would like the representative of NCC, that is Nigeria Communication Commission, to give us his presentation. We learned that no. Yes, so you quickly do the same thing that like Benedict has done. You quickly work within the stipulated time so that we can ask you questions together. Thank you so much.
Okay, good afternoon, everybody. Distinguished Senator, Chairman, and other participants in this program. I won't bore us with too many details. The first speaker has done a lot of work in speaking to the internet, what the internet is, what cybercrime is, and also speaking to what the critical issues are as to an awareness situation, is whether there's a situation of a skills gap, also as to whether we have enough provisions within our laws to deal with the issues we are facing. So I wouldn't go too much into details in my paper. I'll just say that today, in terms of the subscriber base for telecoms subscribers in Nigeria, particularly mobile subscribers, as of September 2020, we had over 200 million active lines. And then we have over 151 million internet users. When we say internet users, we're talking about people who have access to the internet, not necessarily at the highest level of experience, like 4G and 4G plus and 5G. We don't have 5G in Nigeria yet. We're working towards that. But that tells you the kind of impact zone that you can have with cyber crimes, and also the number of persons on the internet just locally in Nigeria, and the level of and the level of incidents that you can have, because you have so many people on the internet at the same time. So it's actually very difficult to be able to police these incidences as a nation if your infrastructure is not up to scratch. Part of the problems we're experiencing today in Nigeria is because our internet experience at the very best level is relegated to our major cities. The infrastructure we have today is infrastructure that exists to the best level in our major cities. If you go to the rural areas, the semi-urban areas, you find you don't have enough infrastructure, so there are quite a lot of gaps. The NCC has made a lot of interventions in this area in its USPF plan to get investors, that's incentivize investors to go into rural areas and provide infrastructure, as well as our InfraCo plan to get investors to also provide fiber. This then raises the issue of how we can handle the challenges we are facing. Yes, there is an awareness gap. There is an awareness gap. We find that while not denigrating the efforts of law enforcement, we find that we don't have as much capacity as is required to even comprehend the extent of cybercrime that is going on in Nigeria. The EFCC is doing a good job, but to what extent does it have the capacity to deal with advanced fee fraud and the various forms of cybercrime we are seeing? You find that cyber criminals are usually very experienced people. Yes, you can find the ones who operate at the basic level, who hack your phones or who try to access your SIM card and go and do a SIM swap and try to access your bank account. They work within syndicates and they use that to steal your money. I don't know if a CBN representative is here. It would have been very nice to have a perspective from the CBN, because the CBN has put in a directive that makes banks liable prima facie if your money disappears from your account because of a SIM swap, an illegal SIM swap. The perpetrators form a ring with the IT guys at the back end in the bank, and they also form, yes, they have to have that network. They have that ring there. They also have people at the registration end for mobile networks. The primary network would always ask you to come to their center to get your SIM activated, but you find that sometimes because of volume, they have agents who do registration for them. At the sub-level, you find some of them are able to clone or you basically register SIMs in a manner where you can't really get the actual identity of the person. NCC has had to do a lot of investigation and work on this area with the NSCDC. You find that they will register maybe 50 people with the same identity. By the time you get to the back end, sorting out that data becomes a challenge. We manage the central database for telecoms subscribers, but we are doing that on behalf of the Office of the National Security Advisor. So you find that scrubbing the data to match your picture, all the biometrics together for one person is quite a challenging task because of all of these nefarious activities. So these are some of the loopholes you are having in the system. The fact that you don't have enough connectivity, backbone connectivity, so signals can be seamless. The fact that even data management is a problem. The fact that we have our information in this country contained in silos. You have NIMSI has its own records. You have the police, you have the customs guys, you have FRSC, you have so many of them. They just have immigration. They have different silos of data. We don't have, like the countries we can compare to, the US, the UK, those comprehensive national data records. If you go to Dubai, for example, once you land and you are at the airport, you are doing your immigration process, all of your records are going to a central database. Everywhere you go to make a purchase, to buy something, they will ask for a copy of your passport. In fact, the hotel will retain your original passport and give you a copy of your biodata page. Everywhere you go to make a purchase, they will ask for that biodata page. While they are trying to enter your sales, they are actually hitting the national database to compare the records you submitted at the airport. So they have your identity. So they can tell what you did when you were in Dubai, where you went to, and who you are generally. So that's something that's missing in our ecosystem. The new efforts we are making to get investors for wireless fiber infrastructure, as well as incentivize them to provide other ancillary services, is one way in which we are trying to bridge this gap. We also know that there are new services that are coming that are not challenged by the fact that you have to get so many regulatory approvals from state governments, local governments, and all of that. These are some of the challenges we have. There are new internet services that are coming that do not require all of these terrestrial challenges. For example, you have low Earth orbiting satellites, which when deployed will basically give you the same speed of fiber internet on satellite platforms, and then that makes it easy for you to communicate. This, of course, is a win and a negative, because it then enhances the platforms that cyber criminals can use to get at you. The Commission also has tried to create subsidiary legislation, more like what the NDPR has done, to provide for data protection to some extent. We have our registration of telephone subscribers regulations, which protects the confidentiality of your records as a telecoms subscriber. It also makes it difficult for anybody to access your information without being a person specified within the interpretation sections of that regulation. For example, it has to be somebody from the rank of Assistant Commissioner of Police upwards in any of the enforcement agencies, the law enforcement agencies. We also have our Consumer Code of Practice regulations, which also provides extensively for protection of subscriber data, and then places obligations on telecoms licensees to ensure that they do not release your information without your consent, and then also without the appropriate legal backing. I don't want to start speaking to every page of my presentation. I can just speak to some of the suggestions we have made, for our cyber law and data protection framework to be better. On page 8 of my paper, we have said we need to see more advocacy to support public awareness and the effort towards the passage of a harmonized data protection law for the country. I think the NDPR is good, but it would be better if we have a substantive act which is all-encompassing, because we have silos of data protection information in many laws. It's very important to have data end-to-end encryption and within your networks. For example, you see with WhatsApp, there's greater protection for your communication in WhatsApp. Yes, the law enforcement agencies, if they have the encryption keys, they can still hack into your communication. Yes, they can, because all you need to do is to have the encryption keys. That's the truth. If they have the encryption keys, they can easily break that communication and see what you are doing, which is why sometimes you'll be surprised that somebody says this person is making insensitive comments about the government or whatever, and the person will not understand how his information was basically hacked. Because it's true, because even we have a regulation which we have passed, which allows for lawful interception of communications. This is supposed to be done towards helping to deal with crime, but abuse is always there in any situation. So you also have the issue of awareness. We continually hold an annual workshop for law enforcement agencies, as well as capacity building for judges and then for legislators. The truth is there are many critical professionals who do not understand how this industry works. And so it becomes a problem when you ask them to adjudicate, or when you ask them to litigate, or when you ask them to enforce, because many of them don't have the skills. And that's why the first speaker spoke about is whether it's possible that the questions we need to answer is whether there's a skills gap or not. There's actually a major skills gap. Then we have the fact of personal security, which the moderator spoke about. He had spoken about whether you need to have personal security. Yes, you need to. Organizations need to have strong investment plans in security, data security. If you don't have that, people who have the experience to breach what you have will breach it very easily, because there are a lot of people who are really skilled in this area. They can hack most systems, most software you have. There are types of software they push into your system. It's called a ransomware. That ransomware goes into your system and basically holds it captive, and then asks you to make a payment, mostly in bitcoins, like he said. You have to make a payment before they can free up your network for you to be able to access your organizational information. Even when you store your information in a data bank, which is what you call the cloud. The cloud is not the clouds we see. It's actually a data center where you have dedicated servers. Even if you put your information there, the integrity of your information and the safety of your information is as strong as the protections that data center has. So it's never a 100% situation. But we need to have more investment in so many critical areas. again, we need to have insurance policies that cater to this sector. I don't know how well the insurance industry has developed packages for protecting networks and protecting organizational data. My last point will be on the issue of the effort we have made in supporting the Office of the National Security Advisor in developing and managing a computer incidents response center. We have one in Wusetu in Abuja. It is a place where people can report data breaches. This one we have is specific to the government, but we are encouraging sectors, maybe the finance sector, agri, whatever, to develop sectoral centers like that, where you can report your breaches, computer breaches, hacking, and all of that, so that incidences can be logged, reviewed, and treated. People can provide expert advice, and also if they need to provide intervention, they can do that. Because you have what you call ethical hacking. So they can also return the hacking back to the hacker and block his access to you. But bottom line is you are responsible to a large extent for the protection of your own data. That's the truth. So that's my paper for you.
Okay, Mike, thank you so much, Mr. Balogu Christopher. Abba. Okay. Okay. Mr. Abang, you really represented the EVP very well. Mr. Dambata, Professor Dambata, I mean. This is a very nice presentation. Like I said in the first paper, we reserve our questions because we want to take the same lines of a paper presentation on the same topic. Then we'll now ask our questions together. Without wasting much of your time, we would like to call Mr. Christopher Balogu to make his presentation. 5 minutes, please. I know you can do that. Thank you so much.
I want to appreciate the coordinator of this Rule of Law Convention. I want to appreciate our chairman, distinguished Senator Oseni. I'm not here to patronize you, sir, but I want to thank you for effective representation in your constituency. I happen to work in one of the universities in Nigeria, and some of our students have been beneficiary of your generosity. And I want you to keep it up. Please, on the issue of 5 minutes, before I've been informed by the robust and intellectualism of our legal practitioners, and I've been humbled to always that I will ask and permit you to give me at least 10 minutes. Okay, thank you very much. Okay, I don't want to be prosecuted for it. Sir, my presentation has to be on the recent attempt by the National Assembly to regulate information on the social media versus the rights of the citizen to freedom of speech. This conference actually informed my understanding of the Constitution. No matter your position, whether you have good intention or bad intention, when it negates the Constitution, there's already a problem. What is the constitutional interpretation of it? So in my own paper, being a member of the academia, we have a way of doing our presentation, and I try to look at it by what the Constitution is saying per time. Like the recent attempt by the National Assembly to regulate information on social media has sparked a public outcry, and it's creating an attendant crisis that even threatening to worsen the crisis of national unity and security that those proposed bills seek to address. To achieve a proper understanding of these controversies this bill has generated, it is imperative that we conceptualize the following variables, which are the following. Meaning of democracy, because we're in a democratic government, it features on the basic rights of the citizens, the National Assembly and its basic function, and Nigerian Constitution, the meaning of social media merit and demerit, the 2015 anti-social media bills and 2019 social media bill, and the response by Nigerians. We all know that Nigeria is a product of colonialism with experienced both democracy and military rule since independence. Presently, we're under democracy. Any democratic government, no matter which type of system of government they operate, has almost same features. Democracy originates from the Greek words demos, meaning the people, and kratos, meaning to rule. Democracy is a system of government in which power and civil responsibility are exercised by all adult citizens, directly or through their freely elected representatives. It rests on the principles of majority and individual rights. The key features of democracy, I take 1 and 4. All major decisions are made by the elected leader, who are representatives of the people. The law and say respect for rule of law and fundamental rights are granted to each and every citizen in the country. With respect to the Nigerian state on fundamental rights, these rights are codified in the 1999 Nigerian Constitution, Chapter 4. Formation of the rights of the citizen are a right to life, right to dignity of human person, right to personal liberty, right to free hearing, and the last, right to freedom of expression and the press. So, the Section 39 of the Nigerian Constitution guarantees every Nigerian citizen the right to freedom of expression, including freedom to hold opinion and to receive impact ideas and information without interference. Sir, I believe on this note that the social media bill was first registered in 2015 and also in 2019 because it negates the basic principles of democracy and the constitutional provision on fundamental rights of Nigeria. When we look at the Freedom of Information Act by President Jonathan, this act was assented to by President Goodluck Jonathan on May 20, 2011. This Freedom of Information Act supersedes the Official Secret Act. The Official Secret Act originally enacted in 1911, which forbade authorized transmission, obtaining, reproduction, or retention of classified matters. We are no more under the Official Secret of colonialism. We are in the modern age, sir. This act, that is Jonathan Freedom of Information Act by Jonathan, he said, this act gives persons, groups, associations, or organizations the right to information from government agency, parastatals, the federal civil service, private and public sectors, and organizations providing public services. This act surely undermines the capacity of the legislature to curtail the rights of the citizen to information. We are not talking about other cyber crimes by 419. We are limiting ourselves to the right of the citizen on information. I'm very clear about my presentation, sir. We shall examine the National Assembly, its roles and function. The National Assembly of the Federal Republic of Nigeria is a bicameral legislature established under Section 4 of the Nigeria's Constitution. It consists of 109 Senate members and 360 House of Representative members. All members are elected directly every 4 years and structured to guarantee equal representation with 3 senators to each state of the total 36 states, irrespective of the size of the state, and a senator representing the Federal Capital Territory. The House of Representatives is divided into 360 federal constituencies, each of these, which is represented by 1 member in the House of Representatives. At the state level, the legislative power is vested in the House of Assembly, whose seats ranges from 24 to 40 members, depending on the population of a particular state. We look at the functions of the legislature. They perform lawmaking function through researching, writing, and passing of legislation. The second one is oversight functions for the executive. But the third one I'm going to be emphatic about, which is representation. This includes constituent function. Members represent their district and constituency and help to make requests for help from citizens within it. They deliberate on public issues, problems, and needs. The debate held in the legislature has a great educative value for the people they represent. So I'm quoting from the Constitution of the Federal Republic of Nigeria, sir. The legislature acts as the highest forum of ventilation of public grievances against the executives and represents every interest and shade of opinion and public aspiration. They protect the constituents of the people they represent by being their eyes, ears, or voices. The question I'm going to ask now, because I'm happy I'm in the midst of legal luminaries and legal giants. The question is, will the legislature muzzle or emasculate the rights of the constituency they represent? Their recent incursion into the process of regulation of social media that they had regulated through the Cyber Crimes Act of 2015 is an antithesis of the role and function of the constituency they represent. Sir, I have been seeing this book for the past 9 months, but because I wasn't informed, I didn't even know what it represents. But yesterday, I opened it and I was so happy. Page 4 of it, 4 and 5 of it, stated in part 3, offenses and penalties, which the offense against critical national information infrastructure, unlawful access to a computer, that is Cyber Crimes Act 2015. I think our most informed legal practitioners have them. Then to page 5, talks about the duties of financial institutions. Part 5 talks about administration and enforcement statistics. In August 24, 2020, reported that Nigeria's economy effectively slid into recession in 2016. This has led to the devaluation of Naira. So in 2018, the Monetary Policy Committee, which is the highest policy-making committee of Central Bank of Nigeria, warned that Nigeria's economy risks slipping into another recession if there was no synergy between the monetary and fiscal policy to ensure macroeconomic stability. The World Bank also reported in 2020 that the Nigerian economy faces world recession in 4 years. Though collapse of oil and price and COVID-19 pandemic aggravated this crisis. The IMF, International Monetary Fund, gave the following statistics about the inflation level in Nigeria. By way of comparative analysis, we look at the inflation level. Okay. We look at the inflation level. As of 2013, it stood at 8.5%. 2015, it shot up to 13.39%. And 2015 it was 15.7%. And 2020, 13.39%. The International Labour Organization gave the following information about Nigeria's youth unemployment level. I'm providing this information so that we know where we are going, sir. 2011, 9.56. 2012, 9.71. Inflation unemployment, Nigeria's youth unemployment level. 2013, 9.85. 2014, 8.41. 2015, 7.81. As 2016, it rose to 12.48. 2017, 13.96, 2018, 13.72, 2019, 13.96, 2020, 14.17. These are causes of the youth crisis, unemployment, and other demonstrations that we are seeing from them. These are not the making of Nigerians, but informed organizations or institutions that use the service of experts for their analysis. The National Bureau of Statistics on 4th May 2020 reported that 40% of, that is our National Bureau of Statistics, reported that 40%, that's 82% Nigeria live below poverty level, less than $1 per day. According to IMF media report also on Nigerian debt profile, in January 2015, the total debt was 12.06 trillion naira, but as of 2020, it stood at 31.01 trillion naira. See, when you look at all this, you know that the economy of the country is not faring well. Then we look at other non-information, which include the other issues that borders Nigeria, the retention of underperforming service chief, despite the security situation and public outcry, lopsidedness of appointment into key position, unlawful detention. The implication of all this is that the social media is there to give all this information, and when they give you, honestly, it diminishes, it reduces our public confidence in what is going on, and there's no way people will respond, because it gives that forum for them to ventilate their grievances, and it's your duty, sir, to allow it, because even you perform oversight function without the legislation, the executive won't perform. So that's why the intent to read this out. So I quickly go back to the demerits of the social media. Number one, say you can easily receive negative feedback of your actions.
Yeah, be conscious of your time, please.
Okay, I'll round
We're
up.
almost done.
Okay. The merits, he said you can easily receive negative feedback of your action, policy, or product, and the feedback and criticism are exposed to others. I'm sorry, that's what is happening now. When the government is not performing, honestly, the people know, the world knows, and they circulate on social media. So when you talk about regulation of social versus the right of the people, the attempt to come out with this bill, the first attempt to regulate information on social media started with a bill titled Bill to Act to prohibit frivolous petition and other matters connected there with, sponsored by Senator Bala Naala. This bill passed the second reading, but President Muhammadu Buhari distanced himself from it. That's why the lawmaker withdrew the bill. The Senate reintroduced the bill in November 5, 2019. In fact, part of the bill first seeks to criminalize the use of social media, pending malicious or false information, and the proposed death sentence for hate speech. They later withdrew it because of public outcry and pressure. Where we are going now, the Nigeria Communication Commission and the Broadcasting Organization of Nigeria had overwhelming consensus that most of the bill's provisions were already captured in previous legislation like the Cyber Act Crime of 2015 and the Nation Penal Code. I will briefly go into the NSAS protest. The momentum it gathers honestly put Nigeria under pressure because the youth, they started demanding their government to take responsibility for their weak action. And this didn't go down well. With the Lekki shooting, the federal government launched a fresh campaign to regulate the social media to curb fake news. And honestly, though the Minister of Information spoke about it, backed by the 19 northern state governors, they want the National Assembly to ensure that the executive arms, they want the National Assembly to pass it into law. But it generates reactions by Nigerians, and the reaction is not too positive for our fragile stability or national security that we are trying to preserve. Khan has spoken. Sarah, that is the Social Economic Rights and Accountability Project. Groups, individuals, they've spoken, and even they challenge the government. Some even threatening to sue the government if it's being passed into law. The Amnesty International stated that the proposed bill to regulate the social media, which was opposed by the Information Minister, is not the right. In fact, the government is quick to apprehend the peaceful protester, and they freeze their account. But those perceived sponsors for terrorism that we've been hearing for the past 10 years, their account wasn't frozen. So that is the area where some of us have issues. The president of the Nigeria Bar Association, Barrister Olumide Akpata, said federal government plans to introduce regulation of social media after NSAS protest is suspicious, as the social media space is already regulated. What we are trying to see is that you provided that it's already regulated, though we cannot deny that social media platforms be abused. We've spoken about it. But I will prefer the following solution. Like in my recommendation, we said the National Assembly should please preserve Nigeria state and democracy by withdrawing every attempt to regulate information on the social media, since this will undermine the fundamental human rights of the citizen and will lead to gradual collapse of the Nigeria state into anarchy. In case, they should strengthen the implementation of the cyber crimes law and the effectiveness of the acts. If the effectiveness of this act is strengthened, I know you have your system of committee inviting professionals, all these things, experts to look at it. It should be strengthened. You are taking care of any of the related crimes. Then the National Assembly also should advise the executive arms to release all the people that were unlawfully arrested because of their involvement in the NSAS. Committee should be set up to immediately look at the root cause. There's a root cause to this protest and the proximate cause of the protest. The National Assembly should please for those that were perceived to be the sponsors of the peaceful protester. Committee should be set up to look at the role of some government agency with marked and unmarked vehicle, government vehicle that was caught on camera attacking peaceful protesters. That's one of the advantages of this social media. You saw them in their Hilux and their Jeep. Nothing is done about them. And I pray that National Assembly should set up committee to properly investigate the person or group behind the Lekki tollgate shooting with genuine intent to bring them to book. And also make sure that family of those innocent protesters that were killed are compensated, and those logistic. And I will beg that the National Assembly should please advise or check the excesses of the executive when they undermine the provision of the rule of law. Examples abound with the unlawful detention of Colonel Sambo Dansuki, Zakizaki, Soria, and recent arrest of peaceful protesters. Disregard for court ruling, illegal and frivolous appointment of key government officials where due processes were recklessly abandoned. Retention of underperforming service chief. Those give us concern with the security issue. They are not power and you keep them. The National Assembly should also focus more on true representation by judicious implementation of their constituency projects. This will help in an increase in the employment rate and reduction of poverty. And I will pray that the National Assembly finally focus more on passing law that will help enhance the economy of Nigeria, because our debt profile is frightening. Nigeria's debt profile or rather level of indebtedness is worrisome and will definitely lead to the gradual collapse of the Nigeria state, if not curtailed. The reality is that democracy is under threat, and the onus falls on the legislature to salvage Nigeria's fragile democracy. Thank you very much, sir.
Thank you so much, Mr. Balogu.
Yes,
Christopher?
Yes.
I think okay, thank you so much. Please off your mic. We'll quickly take Mrs. Chinelo's presentation. Then, before we, please still be patient with us and hold your questions and contributions so that we can do it together when we are done with the paper presentations. Thank you, Ms. Chinelo. It's over to you. 5 minutes. I know you can work within the time. Thank you.
Thank you, Mr. Chairman, for the opportunity. I am hoping to finish within the time given, but in the event that please I spill into extra time, kindly give me extension of time, sir. I will not take much of our time because my paper has a substantial justice has been done to my paper by the panel the first panel of the day in the morning, and I do not have the intention of repeating what the very qualified personalities and eminent personalities in that panel had done. So my paper is at page 342 of the bundle. I'll quickly jump paragraphs 1 to 25 of my paper because I think that has been discussed extensively. And the part I'm jumping is the part that deals on property rights in Nigeria, the limitations to those rights. I also discussed the previous position of the law in Wigwe and FRN, where the Court of Appeal held that forfeiture without conviction was unconstitutional. And then I went to the position of the new law in Jonathan and FRN, where the Supreme Court set aside the decision. It departed from the decision in Wigwe, which was a Court of Appeal decision, and held that interim forfeiture, I have to keep emphasizing that the Supreme Court has not taken a position on final forfeiture, even though there is a hint in Jonathan and FRN that it may be upheld, but that position is not final yet. I went into that, and I also explained issues surrounding the decision of the Supreme Court and how the Supreme Court may wish to revisit that the principles set in that judgment after, if the opportunity presents itself, because we have looked at similar situations that do not have similar facts, that because it's done abroad is not a sufficient reason why we should do it here, because we do not have the same situations from what we have experienced abroad. But that is what I am jumping. This few points I've made now is what I'm skipping. So I am moving straight to management of confiscated properties. And the paragraph is titled "Relooting the Loot: Management of Proceeds of or Suspected Proceeds of Crime, an Urgent Need for Amendment of Section 17 of the Advanced Free Fraud and Other Fraud-Related Offences Act, 2006, and Introduction of Court Practice Directions." And I started by saying at paragraph 26 that in an earlier paper titled "Forfeiture of Proceeds of Crime under the Nigerian Legal System," this author had posited as follows: historically, Section 17 AFFA is not the first of its kind, legislature having enacted a similar provision in Section 49 of the now defunct Corrupt Practices and Other Related Offences Act 2000. The same legislature, in its wisdom, abandoned the same enactment when the defunct law was replaced by the Corrupt Practices and Other Related Offences Act 2003, following a barrage of legal actions against the old law. Between the year 2006, when the AFFA was passed into law, and the year 2015, stakeholders paid little or no attention to Section 17 of the Act. However, the emergence of the present administration and its anti-corruption crusade exposed the advantages and dangers of equipping state authorities, especially in Africa, with extensive discretionary powers. Now, Section 17 of the Advanced Free Fraud Act is the section that deals on forfeiture without conviction, that permits that an application can be brought before the High Court and forfeiture orders can be made interim and later final. And then the person who is the owner of the property can be divested of their property without conviction. And the Supreme Court has upheld the interim part of that law. I continued by saying that it is therefore recommended that the National Assembly amend Section 17 of the AFFA 2006 by setting a procedure of hearing which does not encroach on a property owner's right to fair hearing and right against double jeopardy. Also, the 14-day period required for a party to show cause why property subject to order of interim forfeiture should not be forfeited to the state should be extended, while notice to the property owner must be direct as first instance. The practice we are used to is that most of these notices are issued on the pages of newspaper. Now, if it is published on the Nation newspaper and you don't read, and sometimes the properties it's a schedule, so you have about 50, 70 properties, and you may not see your name or your property title on those newspaper publications, and so you won't even know that your property is being divested. And in the earlier part of my paper, I had touched on what I think the legislature meant by the two categories of properties subject to forfeiture. I said one is unknown properties belonging to unknown persons, and the other one is property that is suspected to be proceeds of crime. And I said that the notice to be issued should be direct for the ones that are suspected proceeds of crime, for people who are known, because it makes absolutely no sense, in my opinion, that you know the property owner, you have invited me to your office, you have taken statements from me, and then because you have the avenue of going to court to obtain interim forfeiture orders against me, you go to court and then decide to issue notice to me and to the whole world on the pages of newspaper. I don't think that's proper. I think that we should have clear practice directions that clearly identifies and says, if you know Mr. ABC, please take the notice directly to his house, to his address. Give it to him, since you know that you are already suspecting him of committing a criminal offense. For the fact that you know his identity and you are suspecting him of committing a crime, it is also presumed that you know where to find him. You should not serve him on the pages of the newspaper, because he can miss it. And if he misses it after 14 days, you can go back and make that order absolute, thereby putting him under the pressure of going back to court to challenge notice or to appeal, which shouldn't be the case. The law should make life easier for citizens and not more difficult. And then I continued by saying that otherwise, that if the legislature doesn't take that step as quickly as possible, it is hoped that when opportunity presents, our court will issue practice directions for civil proceedings for forfeiture, including directions on receivership, maintenance, and restitution. It is no longer news that there is a bill to establish process of crime recovery and management agency pending before the National Assembly presently. This was the paper this paper was before. I'm just repeating what I wrote before because this was before the termination of the old assembly, and I know that bill was not passed into law. So by practice, the bill is supposed to come back for first reading again. So I take it to be that we are back. We are now in the new assembly, and that bill is still pending. The agency sought to be established shall have the power to coordinate and enforce all other laws on investigation, identification, tracing, and recovery of proceeds of unlawful activities. While there is a seeming sense of excitement among stakeholders about the proposed law, one may argue that the bill, if passed into law, will amount to the furtherance of a multiplicity of anti-graft legislations and agencies. The duty to coordinate and enforce anti-graft laws is already legislated under the EFCC Act. The issue of asset management can also be assigned and executed by already existing federal government agencies, thereby saving the cost of governance. Because if you're going to create another agency, you're going to hire staff, you're going to pay for training, and even before they take off, it might not be during the life of this administration. A lot has to go into the planning of that agency. But we have other agencies that are already trained, that we can find a way of amending their own acts and creating an opportunity for them to bring in their expertise and their professionalism in doing these things. Then if it does not work, we can know how to proceed therefrom. And then I said that the issue of asset management can be assigned and executed by already existing federal government agencies, thereby saving the cost of governance. It is therefore recommended with respect that the legislature abandon the aforesaid bill, same being a waste of legislative time and resources. I know there are a lot of people who disagree with this view. I expect the ICPC to also disagree with this view. I don't know, but I'll wait until it's their time to respond. Now, this was what I said before. Now, this is what is happening now. It is no doubt that the Nigerian political and public service modus operandi is predictable, not only because there is an ever-growing culture of impunity in service, but also owing to the fact that the failure to consider foreseeable human factor in the build-up to any progressive apparatus of government leads to failure. Over the years, the EFCC, charged with the responsibility of recovering looted public and private resources, have been accused of various levels of mismanagement of relooting of funds and properties in its custody. Like every other allegation of corruption against politically exposed persons in Nigeria, these allegations continued unaddressed until the 6th of July 2020, when Nigerians woke up to the news that the acting chairman of the EFCC had been summoned before an investigation panel in Gestapo style over alleged mismanagement and relooting of recovered loot in his custody. The embattled anti-corruption SAR remains suspended from office while investigations have continued in what many believe to be a political witch hunt than a quest for justice. However, recent events confirm the predictions in the preceding paragraph that the inadequacy of existing laws on civil forfeiture in Nigeria, coupled with the absence of practice directions, is an invitation to even higher corruption in the system. Ours is a system where data and its value in planning and record keeping is underemphasized in public service, not because of the inadequacy of resources, but for the deliberate and selfish need of individuals to practice systemic corruption. It is therefore not a surprise that those who are charged with the responsibility to hold Nigerians accountable have been found wanting and questionable. However, the bulk of blame does not stop at the table of the anti-graft authorities. What has now erupted as a national embarrassment is a failure of stakeholders to develop an apparatus for accountability in the anti-corruption crusade of government. As submitted earlier, there are no laws, rules, or regulations governing receivership, maintenance, and restitution in forfeiture. Therefore, what seems to have been a case of legislative oversight in the enactment of the FR 2006 turned into a vacuum for possible corruption and abuse of property rights of individuals. Interim and final forfeiture applications before Nigerian courts inter alia seek orders of courts forfeiting named properties to the federal government. When such orders are granted as the case in many of the applications, especially in applications for interim forfeiture, the applicant commences management of such properties in a manner that does not take into account the non-abolished rights of the property owner. For instance, where property subject to an interim order of forfeiture is a commercial building, the applicant appoints property managers who charge and collect rent from the tenants and lessees without the knowledge and information of the property owner, whose right is only suspended in the interim. Now, you even have cases where once they come to your property and say EFCC keep off, the tenants say they are not paying again. They just start jubilating that the landlord is in trouble, therefore they will never pay rent. Even when you go to court and vacate those orders, they will keep saying, well, the EFCC has not come to clean the EFCC keep off, therefore they are not going to pay you any money. It's EFCC they will pay. Meanwhile, if you ask them, they've not gone to EFCC to pay any money. So you are there suffering economic hardship based on the inadequacy of regulations for us to know where one thing starts and the other ends. And I also continued by saying that, for instance, where the property subject to an interim order of forfeiture is a commercial building, the applicant appoints property managers who charge and collect rent for tenants from tenant lessees without the knowledge or information of the property owner, whose rights is only suspended in the interim. Such powers to manage properties and receive rents are oftentimes arbitrarily exercised, and the custody of monies received in the process undisclosed to the courts. In other cases where cash is subject to forfeiture, there is no designated or named account for depositing such funds. So you make orders, you say you've collected cash from so and so person, and nobody knows where those monies are being paid into. I feel that the court should have designated account numbers, not just saying this money is forfeited to the federal government. Since it's interim order, there should be custody, known custody for those funds, so that in the event that those orders are being set aside, an order can be made for the particular account where the money is deposited, for the bank to release the money straight to the owner, not for the person to go back again to the agency to start writing letters to say, give me back my money, the court has said the money should be returned to me. Besides, there is no need. We can pay these monies into accounts and we can be making money from them. We shouldn't just have money hanging in the office of the EFCC or the ICPC or any of these prosecuting agencies. Sometimes these are huge amounts of money. You hear things like 100 million, 200 million. These are monies that if you pay it into a fixed account, it can be generating money for the economy and for everybody, and even for the owner of the money in the event that his case is successful in the future. And I also said that in yet some other cases where funds in private accounts are subject to forfeiture or freezing orders, no direction is given on issues relating to interest on account or severance of licit funds mixed with alleged illicit funds. So I have 100,000 naira in my account and someone pays in 2 million naira, and you are suspecting that the 2 million naira is a proceed of crime, and then you freeze my account. What happens to at least the 100,000 naira that is mine? I know it may not be significant enough for the 2 million naira, but I should be allowed to take the 100,000 naira, and then the court can hold the 2 million while we go through the entire process. So we just make blanket orders, freeze people's accounts, and we expect them to come to court. If my account is frozen, how am I going to pay a lawyer? How am I going to get someone to come to court to defend me when I cannot pay? So I have to go and borrow money from people to defend myself when I have money that is legitimately mine, at least, that you are not contending with me in that same account. So I think these are facts that we can put, or the courts can demand to be put in their affidavits, so that in making the orders, the court can make orders to say so and so limit of amount can be removed from the account while this can remain in the account. And I also went further to say that properties subject to forfeiture depreciate in value while in the custody of the state. This one, the major example I can give here is for maybe movable properties like vehicles. You can maybe a car worth 15 million naira at the time of seizure, and this car is kept in the custody of the state, and nobody is driving it. The property owner is not driving it. The state is not driving it, and it's just parked there. And the case can go on for 5 years. I know one case that has been on since 2015. The matter is still in court. The cars are still in the custody of the EFCC. And the car is depreciating in value. So even at the end of the day, it's a lose-lose for everybody. If, let's say, the courts give judgments for the EFCC, and the EFCC has to sell the property, it has depreciated in value. They can never get 50 million out of that vehicle anymore. And what you were looking for was 15 million naira. You said, I've stolen 15 million, I use it to buy a car. You've collected the car. By the time you sell the car, it's worth maybe 3 million. You've cheated yourself, and I have cheated myself too. In the event that I get judgment, and the car is returned to me, and I don't have the value for the car anymore, I can now go to court and start suing again. And then the federal government will lose more money for the mistake that was done ahead of time. So how about we have a solution whereby if you have properties that will depreciate in value like that, for instance, 15 million naira, the court can call the person and give him the option. Deposit 15 million naira into so and so account. Take your car and go. This is the worth of the property. If at the end of the day, judgment is given in my favor, my money is returned to me. If it is against me, the money goes to the state. These are options that we can explore in the practice directions or in the legislations or regulations that we can develop. And I said, in the event that a respondent suffers loss or damages as a result of temporal forfeiture of his property, the law makes no provision for restitution. It is therefore arguable that the Nigerian forfeiture laws as presently constituted is neither human rights compliant nor transparent. Little wonder the various agencies of government have no consensus of records of recovered loot. The court, with respect, also does not seem to have a central record of the totality of recovered loot forfeited to the state. The lack of accountability therefore sets the stage for the relooting of recovered loot, thereby defeating the mischief sought to be corrected through civil and criminal forfeiture laws. In other words, not only does the state expend its resources in the prosecution and hunting of stolen wealth, such efforts are ridiculed or put to question when the government itself is unable to account for its stewardship. Therefore, there is room for the amendment of the FR 2006 and, more importantly, for the introduction of court practice directions for forfeiture proceedings, with special emphasis on notice, receivership, management, and restitution. Property managers must be duly appointed courts and subject to routine supervision of the courts. Cash subject to forfeiture should be paid into public accounts expressly designated by the court and managed by an agency of government, which must not be the applicant in every given case. Every court ought to have a central record of all properties subject to interim and final orders of forfeiture for the purpose of checks and balances. The business of anti-corruption agencies of government must be limited to fighting corruption. Therefore, no anti-corruption agency should be allowed to engage in the auctioning or disbursement of properties recovered from looters. There is an ongoing debate that the AGF has set up a committee to auction and dispose of properties that have been recovered from people. And many are arguing that that is beyond the powers of the AGF and that it is the power reserved for the EFCC. And many are referring also to Section 31 of the EFCC Act to say that that power is for the Secretary of the EFCC. These are not things, these are arguments we should not be having. Because when making any law, we should consider this Nigerian factor, that once you have money that the law does not clearly say where we should pay it into, or properties that the law does not name for a particular purpose, somebody is going to take it as free money and it's going to be relooted, or free property, and it's going to be relooted by somebody somewhere. So that is what we have now, where everybody is fighting to take custody of what has been recovered, to sell them, and then the money is said to, the money will be paid into consolidated revenue account. But what happens during the process of that sale? Is the AGF or the EFCC or the ICPC an asset management or auctioning agency? Do they have the expertise? What can we do to ensure that only people, professionals who are skilled in taking responsibilities for those such actions are the ones charged with that function? Not that he who recovers the money will now be the one to dispose of it or reward himself in a kind of a reward system. And I said the possibility of an anti-corruption SAR to oversee, the possibility that an anti-corruption SAR can oversee the direct management of recovered loot not only puts the professionalism of such organization in jeopardy, but also creates room for persecution of both guilty and innocent respondents for the ultimate prize of financial reward. Therefore, restricting our anti-corruption agencies to their primary role will ensure that they also help the state in keeping transparent records of recovered loot in third-party custody. Restitution for respondents will also ensure that state actors are diligent and fair in the prosecution of cases. Even when these steps and even more checks are implemented, it can then be forcefully argued that Nigeria is ready to associate itself with the forfeiture regimes applicable in other crimes. It's at that point that we can all then agree with the Supreme Court that because the UN Charter has said we should help to fight crimes and recover money, then Nigeria should fall in line. But for now, with the way we are, with the legislatures and our attitude, we don't think we are ready yet. And then in conclusion, I said, the anti-corruption crusade is a campaign for the deployment of every arsenal available to the state in an aggressive fight against corruption. The difficulty and delays in securing criminal convictions does not seem to meet state actors well across the globe. The reaction, therefore, is to weaken the constitutional safeguards of the defendant by permanently depriving him of the proceeds of his alleged criminal conduct, either before or without conviction. To the state actors, restitution or forfeiture is the goal of financial crime fighting, and if same can be secured without the hassles of criminal trial, then the prosecution will embrace such option. However, the proponents of the rule of law and due process believe that justice must not be sacrificed on the altar of results. This is especially as our criminal law has evolved to accommodate plea bargain to ease the stress of criminal trials. However, state actors seem more interested in non-conviction recovery of alleged proceeds of crime, which has received the nod of the Nigerian Supreme Court. As indicated by the Supreme Court in Jonathan Supra, British Parliament enacted the Civil Recovery of the Proceeds of Unlawful Conduct and incorporated same into the Proceeds of Crime Act 2002. The aim of the legislation is to complement the criminal regime under the Proceeds of Crime Act 2002. It is noteworthy that unlike Section 17 FFA, the civil forfeiture law in the UK is properly detailed and ensures safeguards for a defendant against loss at the instance of a receiving or recovery forfeiture order. In fact, if you see the poker of the UK, it's a book. I think it's about three. The size is about three of this bundle that we have here. It is noteworthy. The law also expressly forbids orders incompatible with any of the conventional rights within the meaning of the Human Rights Act 1998. Indeed, a prominent problem with our system is the inadequacy of the law, but there is also a bigger problem related to the lack of professionalism and good faith in the application of existing laws. Hence, the average Nigerian respondent feels safer challenging the competence of judicial process of forfeiture other than its merit. The state, therefore, reserves the duty to be transparent and professional in prosecution. It must be noted that an attempt at transparency seems hopeful within the process of crime bill. Unfortunately, the bill, which is yet to be passed into law, entirely permits some simultaneous civil and criminal forfeiture proceedings and multiplicity of agencies. While we reserve comments on the effects of the aforesaid bill, the conversation on extant laws must continue. This is the end of my paper. Thank you, Mr. Chairman, for not stopping me.
Thank you, Ms. Chinelo. I'm just enjoying your presentation. If not, you actually overshoot your time, but no problem. The moderator would like to introduce some of our SAN that just entered before we move to the next person.
Yes. Thank you very much, Mr. Chair. We have with us at the far corner there, E.Y. Kura, Senior Advocate of Nigeria. His paper is tomorrow, so please let us all come out for his paper. And with him is one of the latest senior advocates that made the list, Abdullahi Yaya. Welcome, sir. Congratulations.
Thank you very much. I would like to quickly call on Mr. Kayode. I know you will do justice to time, which is 10 minutes. Let me not say 5 minutes. I'll give you 10 minutes.
Thank you so much, Mr. Chairman, distinguished Senator Yakubu Oseni. Well, as a panelist, my major role is supposed to talk into the paper presented earlier. And then as a practitioner, I've also looked and I have seen that the paper presented is largely concentrated on the legal procedures in court as it affects proceeds of crime. I might probably just have to speak as a practitioner and talk from the angle from which those of us in practice sees it. I think there's a need to really understand what proceeds of crime really represents, and that it basically talks about criminal income, which can manifest themselves in both real and intangible form. Proceeds of corruption and economic crime comprise of the following: property that is derived or that is realized directly or indirectly from a crime. So it's whatever you realize directly or indirectly from a crime, and this could include property resulting from the conversion or transformation of the initial criminal proceed. This is the position of UNCAC. I can go further. I also look at the paper presented by my colleagues, Madam Chinelo. When I look at page 358 of your paper, you talked about the Corrupt Practices and Other Related Offences Act 2000 and talks about its replacement with the Corrupt Practices and Other Related Offences Act 2003. I need to seize this opportunity to correct that. I've heard this statement being made in many fora, and I must say that there is nothing like that. The subsisting law is the Corrupt Practices and Other Related Offences Act 2000. The attempt to have 2003 smuggled into law did not work. And even as at last year, the Honorable Attorney General made a publication in the National Daily saying that the subsisting and existing law is the Corrupt Practices and Other Related Offences Act 2000. Again, I mean to correct the fact that you refer to Section 49 of that Act. Section 49 of the 2000 Act basically talks about dealing in proceeds of crime. But Section 47 talks about forfeiture of asset, while Section 48 basically talks about forfeiture, and this with the issue of forfeiture. Now, speaking further, I also go on. The agency seek to be established by the Poker Bill, which of course which has not been assented, is basically focused on management, is a proceed of crime management agency. And at present, there's an interministerial committee inaugurated by the Office of the Honorable Attorney General. And the role of the agency is to manage and dispose forfeited government asset, which is like having a trial practice of what this committee, this management agency will do. Its role is not investigative and is not prosecutorial. It's basically to deal with asset that has been forfeited to government. Now, for us in practice, we have clear distinction, and we've been able to make clarification between when an asset is in our hand based on that we seize an asset and we are yet to proceed to court. When we are in court, when prosecution has started and then we have assets in court, then we proceed and then follow up an interim forfeiture order, which you spoke on copiously in your paper. When we have an interim forfeiture order, the court gives specific instruction on what needs to be done. Let me speak about when you talked about publication in newspapers. Now, a respondent in a case is present in court. The legal representative is present in court, so he knows the court proceeding. But there are some unregistered third party who have interest in the property. And then when we make publication in court, in the newspaper, it's expected that everybody should have been able to have access to it and be able to register their interest as we proceed on and move on for final forfeiture. And that's one thing that we do. Secondly, when you have some asset and then you have specific addresses, issues of beneficial ownerships are there. Sometimes, in Nigeria, like my colleague from the National Communication Commission says, the country is still fraught with a lot of identity database problem. You understand? So tracing and tracking of people is not still as easy as it seems to be presented. But it's expected that when these publications are made, everybody should be able to have access to it, because that is what the law provided for at present. You talked about recovered asset. Recovered asset, especially on cash, I need to let you know, because I discovered in the course of the paper, so much emphasis is made on practice in EFCC. I sit in here this afternoon to represent the law enforcement agencies. not just one particular law enforcement agency. So I'm going to give you the best practice that we have. And I need to let you know very clearly that when cash are recovered, they are paid into a designated recovery account in the Central Bank of Nigeria. So they don't stay in anybody's hand. I also need to make a clear revocation that there is a difference between when we PND an account, when we restrain an account and put a post-note debit, the money remains in the account of the respondent at the bank. So the only thing is that it cannot have a withdrawal from such account. It's only when an amount is forfeited at that point that we ensure it is transferred into the recovery account with CBN, and from there a final transmission is made to the sub-treasury, to the Consolidated Revenue Fund. So at no point in time does this fund stay in an account controlled by the law enforcement agencies. In fact, we don't have access to it. It is non-withdrawable account, and that is the practice that we actually have. Let me also speak further to some of the things that you mentioned here. You talked about level of mismanagement and relooting of funds and property. Well, I want to say is that if properties are effectively registered, is effectively recorded, I've been able to speak about cash, that there is no access. The law enforcement agencies do not have access to them. And then when you have physical property, the law states very clearly the way these assets has to be dealt in. And we ensure that there's a proper and detailed record for everything. Let me go back to some of the people some of the things that I've written down, because I'll find myself flipping to some of the things that I've written down and then making reaction to some of the things that you have said. Article 20 of UNCAC encourages state parties to put in place measures that will criminalize illicit enrichment. And that is what we did when we are talking about recovery of assets, which is defined as a significant increase in the assets of a public officer that he or she cannot reasonably explain in relation to his or her lawful income. Now, you talk about commingling some minutes earlier. I talked about the fact that, hey, when the account is freezed and then somebody has to go and borrow money to come to the court to come and defend himself, and I asked, why should somebody also take what belongs to the entire public and arrogate it to himself alone in the first instance? Because if what should belong to the entire country is arrogated to an individual and he alone enjoys the benefit of it, in the process of investigation, if he also has some little restraint, I just think it's just fair, because it's basically clear enough that if funds have been commingled in the course of investigation, we need to do a diligent work to be able to make a separation. So an onus will be on both prosecutions and on the respondent to be able to make a proof, depending on what each individual on each side believes in. There are principles and guidelines that governs management of assets, and I need to stay there. Law enforcement objective behind asset recovery is basically paramount, and the good fiscal decisions are very important. When we look at the ICPC Act, Section 38 make copious provisions for how assets can be managed. For perishable assets, it can be disposed. For movable assets, the law provides that these assets can be bonded to the respondent, meaning that the determination of the case in court, he has a responsibility to be able to provide that asset or a value that is equal to the value of the asset as at the time that the processes of prosecution begins, and as at the time and point in which the asset was bonded onto him. These are very, very clear principles that we follow up with. The common object that governs interim management of assets is this: freezing orders are provided to place a restriction on the movement of that asset. Seizure of the asset from the custody of the owner can be effected, and possession is retained by the law enforcement agencies, specialized asset management office, or a court-appointed judicial manager. We have instances in which the court appoints administrators who have to take custody and management of such assets pending determination of the case. Pre-confiscation sales or disposal, in particular of perishable and depreciating assets, and preservation of the proceeds of the sale. Because we talk about the fact that assets get depreciated while they are in the hand of the law enforcement agencies. Now, there are provisions in law, and it's in the ICPC Act, is the Public Procurement Act Section 37 also provides very critically and clearly for how public asset should be managed. So if this asset is already in the final forfeiture order, there are proceedings in which it is managed. When it is on the interim forfeiture order, there are procedures and processes in which it is managed. The law also provides for interim use by law enforcement agencies or government agencies, and then destruction of unsafe or hazardous property. Now, let me speak about what the ICPC Act says, the Corrupt Practices and Other Related Offences Act 2000. Section 38 of this act made very clear provisions on management of recovered assets. It says that assets may temporarily be returned to the owner or person from which it was seized, subject to such terms and conditions as may be imposed. So this is clear. And subject to sufficient security being furnished in order that the movable property shall be surrendered on demand to the commission, or furnish a security in an amount which represents the open market value of such assets on the date for which it was seized. So we recognize the fact that often law enforcement agencies, we are not asset managers, we are law enforcement agents, but we have responsibility for preservation of the assets, and then there are various provisions made for preservation. It can be bonded, it can be returned to the victim and bonded, it can be handed over to asset manager, and then it can also be retained in diverse ways. Perishable asset may be sold at the prevailing market value, and the commission shall hold the proceeds of the sales, presumably in an interest yielding account, after deducting the costs and expenses of the maintenance and of the sales of the property. Also making a reference to the Asset Tracing, Recovery and Management Act 2019, the Honorable Attorney General of the Federation and Minister of Justice, in furtherance to the Presidential Executive Order number 6 of 2018, made the Asset Tracing, Recovery and Management Order 2019, which among other things prescribe procedures to ensure effective coordination of the seizures and disposal of assets proved to be legally acquired or proceeds of crime. We talk about duplication of agencies. Now, the belief and the push and the argument for us in law enforcement agencies that let the law enforcement agents stay on their main mandate, which is investigation and prosecution. And I shared your position when you say that law enforcement agents should equally not be the one to manage the asset or to dispose asset, which we all shared, and that is what is giving rise to this issue of the management agency. And what is obtainable now, what the Attorney General has done, is that first, on the 17th of September 2019, so 2 months ago, there was a launching of a central database in which all law enforcement agencies in the country and all asset recovery agencies in the country submit and front load information about recovered assets, so that one, we can have a common database, two, we can have one single holistic and uniform management of this asset. And on the 2nd of November this same year, an interministerial agency was set up, not consisting of law enforcement agencies, but consisting of all agencies of government that has to deal with recovery of government properties and revenue, so that there will be transparency and accountability. And what that simply means is that, one, well, if you leave these assets unattended, they keep depreciating. A lot of them get so bad. At the end of the day, the person from which we recover the asset from gets no value. Government gets no value. And the government set up an intermediary agency so that the fact that you are the primary agent responsible for the recovery of assets does not now mean that you are going to dispose. It is disposed in the central pool where everybody is involved. And I need both to let you know that this intermediary agency consists of various professionals. Ministry of Works represented for valuation, Ministry of Finance is there, the Navy is there, all the law enforcement agency, NSCDC is there, ICPC, EFCC, the Nigerian Police, the Joint Task Force of the military is there. Everybody involved in asset recovery are present on this committee to ensure that there's absolute transparency of whatever is being done. And I also noticed that you talked about failure of stakeholders to develop an apparatus for accountability in the anti-corruption crusade. And I agree with you absolutely. I challenge everyone. And this is the position that the ICPC has been pushing for a while. Let everybody be interested in what is happening. Let us hold our legislators to account. Let us hold our local government chairmen to account. Let us hold our government to account. And that is the essence of the Open Government Initiative. Now, I must let you know, when you talk about appointing property managers who charge and collect rent from right, property managers, when they are appointed, it's basically to ensure that the property do not depreciate beyond value, and every proceed collected are paid into this account in the CBN. And I've also made a clarification between when account is placed on restriction, post-no debit, and then when it is forfeited. And I also need to talk about, this is the current price. Cash subject to forfeiture should be paid into public account. I have cleared that. And I've talked about the interministerial committee. And so I want to believe that I've been able to address some of the things that you have said. And I just conclude by saying that when you talk about disposal of public properties or forfeited assets, the Property Procurement Act 2007, precisely section 55, subsection 6, clearly states the way that public assets should be dealt with. It says the means of disposal of public assets shall include sale and rental, lease and hire purchase, licenses and tenancies, franchise and auction, transfer from one government department to another with or without adjustment, and over to public at an authorized variation. And everything that law enforcement agency does, and which interministerial agency on the forfeiture of government asset, which is charged with responsibility to get this done in about 6 months. And what they are dealing with now is those assets that are on final forfeiture, not assets on interim forfeiture. And the committee also has a responsibility to see that there is a monitoring. There are some assets that you can find on final forfeiture for the past 5 years, 6 years, and they have not been transmitted into interim forfeiture for the past 5 or 6 years, and they have not proceeded to the stage of final forfeiture. Then you ask the question, what has happened? Or what is happening? The whole essence of the Interministerial Agency Committee now is to monitor and keep a traction and ensure that there is proper accountability and transparency in monitoring recovered and government forfeited assets. So managing these assets as a going concern. What we were able to develop in our commission, the ICPC, is to ensure that when going concerns are on interim forfeiture order, it is bonded to the assistant manager so that the assets still operating, there is no loss of job, there's no depreciation of the value, and then the economy gains of the asset is still retained by the public. We are much more concerned about public interest. But in such case, you bond the managers, and then you ensure that they render monthly or regular account to the commission, because the commission at that point is the representative of the federal government, the management of that asset, until when it is finally forfeited. On this note, I might just want to conclude and state that for us too, we have challenges which I think you need to really understand with us. There is a challenge of the beneficial ownership. There is a challenge of identity management. And there is also the challenges of technicalities when you're in court. But however, we recognize the fact that the whole essence of asset recovery is to ensure that criminals don't continue to get value and enjoy the benefit of the asset, even while prosecution is on and the general public is at a loss. Thank you.
Thank you so much, Mr. Kayode. It's a wonderful dissection of Chinelo's presentation. We appreciate you, and I don't know whether Mr. Benedict Daudu is still there, because we have come to the last session, which is question and answer, and I would like to start with you, but if you're not there, I'll start with those that are here presently.
Okay. I'm here.
Very good. Thank you for being with us all this while. Yeah, in your presentation, Mr. Benedict, we are able to see that most of the issue that we have with cybercrime can be traced to unemployment, high rate of unemployment level in the country, and you also acknowledge that our people, our youths, are highly intelligent, and that is why they decide to go into that. But I would like to put it to you that with this, our level of intelligence, is it not possible for us to tailor this our knowledge to positive or legitimate means of livelihood? Because if you actually take a look at the sector, that is communications sector, if it's properly harnessed and utilized, and there is an enabling environment, I think it can take more than 50% of our youth off the streets. And if that is the case, I also want to align to add you, the person from Ministry of Communication, because we have a lot to do here, because this is a sector that is open-ended, that if government really wants to bring our youth to limelight, I think this sector can do a lot. And this knowledge, we can equally, if we prepare our youth very well, we can transfer labor offshore. It doesn't really mean that they must operate here. The market is vast. It's there waiting for this. So, what are we doing as government? I'm now referring it to us now, and through communication. What are we doing as government to utilize this vast opportunity in the communication sector to make sure that our youth redirect this our knowledge from criminal activities back to legitimate means of earning? That is for you and Mr. Abam. Then in our sector, there are a lot of people that are using internet users, and we have some gaps. And we have so many private sectors that I believe are operating under you, that we can engage into this area to help us bridge this gap. People like, we have so many of them in Lagos, CyberSoc, CyberDome, Data Plus, and even who are we, all of them, they were here. Why can't we saddle them with this responsibility to do the needful for us? On data management, NIMSI before, they were with presidency. Now, they are now with Ministry of Communication and Digital Economy. That brings me to data harmonization. Before, we can see that our data are scattered everywhere, the immigration, road safety, everybody will want to have their own data. But presently, as we speak, I want to put it back to you, because during our oversight functions on their level of compliance in terms of ICT, we discovered that NIMSI still have the largest, over 50 million people in their database now, and it means that now that they are with you, and they are working in tandem with road safety and even immigration. So virtually we are going towards harmonization of our data, having one system. And now the nation is preparing to go into population, that is MPC, National Population Commission. All these are still data collections and all that. think that NIMSI should brace up and embrace this, the coming of population that we are going to collect data on now. I'm just asking my own so that others will ask, then they can respond. You can write down the questions that I've asked. Mr. Balogu Christopher, yes, we have rights. The government, we have right to life, right to everything, freedom of speech and all that. We know all this. But we should equally know that where your rights stop, another person's right begins. And in a situation where we are not being guided, you can see that that is what actually happened during this answers. It is a very beautiful package in the beginning, but at the end of the day, something else crept in, and it was a different story altogether. That is why we have our legal luminaries, we have judiciary systems that is in place, and we are human beings. We need to be guided. That is why in any nation we have constitution that we are operating on. We have policies of government in various stratas. So, as far as I'm concerned, in as far as we have freedom of speech, freedom of all that, we need to be guided so that we can live in a nation where everybody respects each other's rights. So, and Mrs. Chinelo, I completely align myself with your submission, and because this is what the last session, which is last year, the same position you maintain. And from what Mr. Kayode has said, it is a good one too. You really dissected her position. But my question to that, put to you, Mr. Kayode, is that yes, if at the end of the day you are proved not guilty in the court of competent jurisdiction, is there any measure in place to compensate you as an accused? Because if somebody just wrote petition and you have taken it up and somebody's account is frozen for whatever reason, you will presume that he's guilty and the account is frozen and he's suffering it. He doesn't have money to come to court and all that. If at the end of the day we discover that he's not guilty, is there any measure in place? If there is none, or is there anything that we are putting in place to compensate him for the suffering for that he suffered during the process of prosecution? Because prosecution in Nigeria takes a lot of time, and we need to work on that too. So that is for you, Mr. Kayode. Well, I don't know if anybody else will want to ask one or two questions before they will respond. Okay. Okay. Let our learned.
Mr. Chairman, my learned colleagues, presenters, I don't know the protocol that was said before I came in, but may I raise on the existing protocol, sir? Yes. Now I have, in the paper presented by Chinelo, there's something that is quite bothering. In forfeiture proceedings, there are a lot of problems that have arisen, and some are still lingering and pending. Somebody is being tried in a federal court in relation to a particular offense. Now, and the offense is also alleged to have enriched himself to the extent of buying certain properties. But instead of the forfeiture proceedings being done in that court, the prosecution will now decide to go to another court in another state to commence forfeiture proceedings. And then an interim order will be made which will hamstring the court that is trying the substantive matter, criminal matter elsewhere. Is that proper? That's one. And secondly, as a corollary to that one, Mr. Chairman, the National Assembly has a heavy responsibility to regulate these forfeiture proceedings. I don't think the courts, through whatever subterfuge, can do it. If comprehensive regulations are made by the National Assembly, to say, for instance, if I'm being tried for certain criminal offenses that relate to embezzlement or whatever, forfeiture proceedings must be commenced in the same court. There is no point trying me in a state court and going to do forfeiture proceedings in a federal court. It will not make sense at all. So it is not, I don't think the court can even make anything on that. It is the legislature that should make proceedings to regulate that kind of procedure. Because we find out that with respect to the agencies involved in these trials, they seem to be going after certain favored courts where they can find an ex parte order, get interim forfeiture, and without referring to the court that is trying the substantive matter. It is either that they are afraid that court may not grant, or that they are afraid that the charge there is frivolous. Because if they believe in their charge, the same court that is trying should also be confronted with the issue of forfeiture, so that a decision is taken. And secondly, on that still, the forfeiture is done in such a way that there is even an attempt to get a final forfeiture order in respect of the property that is related to the offense in that court. So what would be my stake as an accused? If a final forfeiture order is made in another court while I'm being tried here, what happens to me when I'm discharged and acquitted? When you have made a final order and they probably appointed a property manager and possibly auctioned the property, what happens to me? I think we need comprehensive legislation to deal with this situation. Otherwise, people's rights will be trampled upon. People will just forfeit their property against the constitutional provisions. And then secondly, there is this issue of, it was raised by Chinelo. The truth of the matter is that you could have licit and illicit funds mixed up in an account. For instance, if I have a salary account, my money goes in there. And you are also alleging that I put in illicit funds there. Then you go ahead and freeze the account. Completely, my family, myself, everybody cannot be taken care of. There should be a way you can determine which money is legitimate, because you know that I earn salary. Unless, of course, the trial, the whole process is meant to completely destroy me as an individual, destroy my entire family life. And I don't think that is the purpose of a criminal trial. So it is either that we seek a legislation that will cover that kind of thing. Because the way the EFCC, sorry to mention the EFCC, ICPC, and the agencies, the way they operate now, it's just you are sitting down, you don't even know that something has been filed. And you see in the page of newspapers that either your account has been frozen or your property has been forfeited temporarily. You start asking what do we do before which court? Somebody, in fact, in the first place, it happens, somebody will even tell you, I saw your name somewhere. That's even before you even get to know which paper. And before you even take steps, a lot of things would have happened. They say 14 days, assuming you got this information on the 15th day, which is possible. Unless we have comprehensive legislation on this forfeiture thing, honestly, you continue to have complains and complains and complains on this. And lastly, sir, this on the social media bill, distinguished senator, you see, sometimes I feel that government has something to be afraid of. If government is not afraid of something, why is government, if you look at the passage quoted by my brother here, that bill is saying, the effect of that bill is that for failure to support your allegation with an affidavit, that what is criminalized is absence of affidavit. It is not the falsity of what I state. So government seems to be afraid of something. Because regulating this social media bill, it is not just, in fact, it is for the first time this language came up, fake news. I didn't know it in the past. I think it was this regime that I started hearing fake news. And people that were now accusing, you are the harbinger of even fake news. They were even calling one of the ministers a liar. Yes, that is the fact. So, if government is not afraid, there should be a way of sieving the truth from the lies. But to say that if I say something today and I don't have an affidavit to back it up, and when it is true, that my only offense is that I didn't bring an affidavit, I think there is something that somebody is hiding somewhere. And I don't think the National Assembly should allow itself to be used for that. If they want to criminalize something, let's see the basis. The basis should be laid bare, so that I know what I'm saying. If I saw, for instance, my friend Paul there doing something wrong and I post it on the social media, I can justify that I saw him. I can justify it. So I should not be gagged because I said I saw Paul. And mostly the complaint of government is that people are, in fact, government's functions are being impeded by fake news, fake reports. Some people will even draw up conclusions from what government has provided and post. Initial reaction of government will be, it's a lie. Subsequent reaction will be, maybe it's true. In fact, finally they will say, okay, that was true, but they will now justify it. That's what government does. So what is the basis of criminalizing what I said in the first place? What's the basis? The Cybercrime Act has taken care of what our fears. It has. But that just information that I'm giving on Facebook, on Twitter, on wherever, that information by the law that is pending, the bill that is pending, should be accompanied by an affidavit. For God's sake, I saw somebody doing something, I should just photograph it and then rush to court, make an affidavit before posting it. Does that make sense? It doesn't make sense. If we want to criminalize something, let's know what you want to do. But don't tell us that we don't have affidavit. Assuming I'm in the village and there's no court there, what happens? There's no court in my village. So I should get a vehicle or charter one keke napep to take me to one court to go and do affidavit. I mean, let's do things that civilized world will say we have done something. Decide what in fact, what is the base of all these cyber crimes? They are already there. Unless we want to duplicate, like Nigerians were used to duplicating things, duplicating laws, duplicating agencies, when we can harmonize them. But we prefer to duplicate. I think we need to do better than that. Thank you, Mr. Chairman.
Thank you so much. Before you talk, I will quickly respond to your please off your mic, please. Yes. You see, well, I don't want to argue on the social media bill, and I want to tell us that this is why we have you people out here. You know, when Mr. Christopher Balogu was presenting, he said we were elected to represent our constituents. Being representing you doesn't just mean that for us it's just to go and make law. To represent your interest in totality. And that is exactly what we are doing. And in bill preparation, after first and second reading, that's what we call public hearing. In this public hearing, all what you've said here now it's open to you. Everybody, the NGOs, every organizations, they are free. It's a free entry, free exit. You are free to come and air your view. Tell us what you want. It's for the public. That is why they call it public hearing. This is what we want to do. What is your view? And I am assuring you, sometimes, in most cases, what comes out from a second reading, at the end of the day, when it's going back, 20% of it will not even go back with it. 80% will be public's opinion, in most cases. So, we have the Cybercrime Act that we are trying to act on. And from what you just said, of course, we can harmonize. We can say, okay, instead of duplication, what we have in this social media bill that we're talking about, some of it is, you are not criticizing it in entirety now. You are pinpointing some areas that you are not okay with. Okay, those areas that we are okay with, okay, let's leave this, put it in the Cybercrime Act, and let's have one this instead of having this everywhere. Everybody will be pursuing their own. I think that will be okay if we can go that way. In order not to waste much of our time, Madam, we want to ask one or two questions.
Yes, Mr. Chairman. Just some few comments and maybe possible question. Okay, thank you very much. My name is Mimi Ayua. I work with OJ Onoja, SAN and Associates. So my interventions is going to be on different folds, sort of. So let me start with one. First of all, let me adopt my Leonard Silks and submissions on the responsibility of the legislature. I was going to say that along the way. So, but let me come back here. I have a question for the representative of Professor Dambata. Unfortunately, it's not law related. It's technical, but the NCC's duties. So I want to find out why after 20 years, thereabout, we still have issues of drop calls, interconnectivity issues, and payment for services not rendered by the mobile operators. So I send a text message, I am debited, and this message is not delivered. In fact, I am informed it is not delivered. So I'm wondering why that's there. Now, secondly, there's an issue that came up about 2 weeks ago with my colleagues. We're having a conversation over someone that we have not seen in 5 years. Now, incidentally, the next day after that conversation, my colleague kept getting notification on his Facebook page of this person whom we had just discussed yesterday that we have not seen in 5 years. Now, I'm wondering, I know that there's a department in NCC that sort of checks phone accessories and phones when they come into the country. You clear them before, it's been sold. Do we have anything, because to my mind, it got to my mind, I'm like, are our devices in any way recording conversations inadvertently? And then sending some of this information to Google and some of these other agencies or corporations where they're doing, they're using all of these analytics to get to us or something. So that's one. Now, I'm done with you. So I will come back to Mr. Kayode. Now, your presentation was okay. I know that Mr. Chairman had already asked you my major question, which talks about what is the compensation for a victim. But then I will draw inspiration from what the speaker, Madam Chinelo, said. She said something that properties subject to forfeiture suffers, in the event that a respondent suffers loss or damages as a result of temporal forfeiture of his property, the law makes no provision for restitution. And I'm going to drag Mr. Chairman into this, I beg your pardon, coming from the National Assembly. Is there a way that we could legislate on this, that in addition to restitution, there should be damages? I honestly think that just returning the victim to where he was before is not enough, because he has suffered, and so he should be. So I think that in line with them, and we could work out something for that. Then Mr. Chris spoke extensively on freedom of expression, and I didn't want to come into it, but I cannot help but say one or two things. So permit me, I beg you, please. Now, I know that under Section 22 of the Constitution, the media has a responsibility to the people. Now, when you talk about the social media bill, trying to regulate the social media, in my mind, or to my in my own opinion, the social media is the new media, and they have a responsibility to the people, and they need to hold the government accountable. So they have to hold the government accountable to the people, and it's via information. And when you try to restrict this whole provision, the duty imposed or given to the media, for me it becomes offensive, or it's in breach of the Constitution. And I think it's something we need to have in mind as we do all of these things. Again, let me just come in from another angle. Recently, the NBC sanctioned media houses for carrying out their duty and responsibility to the people because they aired the NSAS activities. With due respect, sir, every person I know has been guaranteed the right to freedom of expression under Section, I think, 39 and thereabout of the Constitution. I agree, and I consider it's not absolute. There are derogations from that as provided, I think, sub 3, and I think about Section 45 or thereabout. But even at that, these derogations are supposed to be done according to the law. Now, I know that you cannot, in interpreting these provisions, the purpose of the Constitution, of the drafters, is to be taken into account. And I know that the drafters of the Constitution did not intend that this right given through this hand should be taken, through the other hand, absolutely. So I think that in your oversight functions as the legislature, you can also call to order some of these agencies, government agencies, that are operating in breach of the Constitution. Thank you very much. I appreciate it.
Thank you. Any more questions or no questions? One person. That's the last person. You have to come forward. Come and use that mic.
Mine is not question per se, it's just comment. The chairman and other distinguished individuals that are here, let me start on the existing protocol. My name is Ajay Monge from Buhari branch. My comment is just in respect of the solution is trying to profile about some of these forfeitures of these properties in question, so that we safeguard the situation of depreciation in value. You mentioned that in the alternative, such an individual can be compelled to pay the monetary equivalent of such property. But in a situation where that person does not have that money to deposit in lieu of that particular property to avoid that depreciation we're trying to protect here, what do you think we can do in this circumstance? But I would suggest this way. Instead of wasting our time on this issue back and front, I think the challenge we are having as a nation is that we are not doing what is expected of us as various institutions or various law enforcement agencies. Because if a property is forfeited, whether final one or the other way around, there is need for us to take the necessary step. But you can imagine, for example, go to police station today, you see a lot of cars. That's supposed not to even be there in the first instance. If I go there and look, somebody hit my car, please don't worry, I'm forgiving. They will not even allow you to take this car. For reason best not to them. They will now see everywhere jumper with different things. So what I'm saying is that if we can do what is right or expected of us as an individual, go to the right court, and then we should also raise the issue here at the conclusion that even the various courts and institutions should do the needful, because you approach the court so that they will give accelerated hearing, so that at the end of the day nobody will lose. At the end of the day, what we're trying to protect, we're going to achieve it. Because if you allow a particular car all the name of an exhibit park in court for years, at the end of the day, when the judgment is given to you, it just become an empty judgment because the engine is no longer useful, everything is bad. So I will suggest here that it should be part of our recommendation that every institution should live up to the expectation so that at the end of the day, the target that which this particular project is trying to achieve through this program will be able to achieve without anybody losing out here and there. And lastly, sir, we just talk about the issue of crime as suggested by Mr. Ben, that the reason why people are going to crime, this and that. Of course, I want to agree with him partially, in the sense that by my own background, there's no level of poverty or whichever one you call it that will force me to crime. But at the same time, psychologically, not everybody has to share the same feature within it. Yeah. There are some people that can go into it because of little things. So we have to balance the equation. Now, having made that one clear, there are a lot of individuals, because the senator has just called some of these institutions that they should create job here and there. Of course, they are ready. I'm giving an example. I'm a secretary to a particular company. As we speak now, they are planning to lay off some of their workers. Do you know the reason? Because the atmosphere is not conducive for them. They pay the NEPA bill now, I don't know what they call it, whether PHMB or whatever, is too high. And again, the fuel is high. So the cost of employing people, they have to divide that money to all those costs, to run all those costs. So if there's not a conducive atmosphere for this individual, we keep on saying the same story here and there. And on the issue of regulation on the social media, sir, I want to say this without fear, that there is no institution in Nigeria that is not subject to abuse. The National Assembly is abused. The forefather that laid the foundation of the National Assembly is not what is happening there. Everything is abused. And when you come to the judiciary, it's abused. When you come to the executive arms of government, it's abused. If we're not talking about the abuse, then we should scrape this one. Then we should scrape National Assembly, scrape everywhere off. So, but what I want to say is that instead of doing this, wasting and displaying energy on this, there are a lot of laws that have taken care, just like my learned senior have said, that have taken care. Why are we not looking for the application of laws? The problem of Nigeria is not laws. Is how to implement the little one we have. That's why we're now cultivating a habit of amending, bringing, you are even creating problem for we lawyers. Today, another law will come. Before you know, tomorrow morning, another law will come. So it's a more problem for us. Let us harmonize this and let us forge ahead and do the. Thank you very much for the audience.
Thank you so much. Okay. Thank you, Senior.
Sorry, my name is Anoziobi, MNI. I just want to point out something that we experienced recently. If you have ever accompanied a client to EFCC, or you will be embarrassed at some of the violations of your right to privacy. A client of mine is an architect. They had a commission over to develop an estate, and then they invited him, and I went with him. I said to him, they brought all his financial transactions without they did not seek his consent to access those his private information. They now brought a rule and say, you gave so and so person 15 million. On that day, the client paid you 20 million. Does it work for you? The man says to them, it is my money. I paid my fees. Why do you want to know why I paid them the money? There's no complaint against that man. They just harass people and they free their right, to the privacy of the property and all that. Now, even me, some client's money was paid to my client's account. And they came to me and said, why did they pay this to your account? I said, the man has shown you the agreement. He has shown you his entitlement to the money. They have shown you the instruction to pay to me. And I paid him his money. Why do you want to invite me to come and explain what that? So, even in tracing all these for future proceedings, I think that we must bring about some regulation to control the very rampaging nature of these agencies. They take too much liberties in terrorizing people. For the man in the ICP, I have not had an ICP experience, but the EFCC is terrible on it. In fact, you will be shocked at what they will do to you. They will say, put the rule and say, oh, so and so day, you pay so and so money to so. Why did you pay that money? There's no complaint on that. There's no violation you have committed. It's just that because they are law enforcement agencies, they take unbridled liberty in terrorizing private Nigerians, such that people now resort not to pay money to the account. That client of mine did not receive the payment for his property to his account because he's a public servant. He's a lawyer who let them pay this money to account. And then they now want to harass me as to why I received money in my client's account for a transaction I handled of a client. I think that the time has come for proper regulation of some of this to be able to bring about some balance and control and to allow free enterprise to flourish. Otherwise, you develop an underground economy where you cannot even monitor, where it gets worse, where people will be burying money. That's why people bury money in tanks, buried in the ground, and the economy suffers. If you choke free enterprise, it will be worse off for it. That's my contribution and my intervention, sir.
Thank you, SAN. Thank you so much for your contribution. Chinelo, somebody talked about drop calls now. In order not to experience such in the presence of person from NCC, let's quickly allow Benedict to answer before it will drop. Then so that we can be talking. I don't know whether Benedict is still there. Thank you very much. If you
Yes, I am.
you can respond to us quickly before the network.
Yes, I am. Can you hear me? Hello?
We are hearing you. We are hearing you. Go on.
Okay. Distinguished Senator, I think you answered a bit of the question you asked. It is obvious that unemployment plays a factor in the rise of cybercrime. But if we can't ignore a factor such as greed. And if we were to look at Hush Puppy as a social experiment, I would clearly see that the buck didn't stop at him getting adequate resources to take care of himself. There's also the desire to have enough resources to take care of your generation and your great grandchildren. And a lot of it, I think, stems from the exemplary nature of our public officials. Most of them, all of these youth, see some politicians and see the way they live their life with opulence, that they can't help but want to live that same lifestyle. So I think there's also a need for an exemplary lifestyle or change. But who are we lying to? I don't think that would ever happen, at least not now. And so we must tell ourselves the truth. The law must simply be all-encompassing, and the focus should still stay on the law and how much we can actually reform and restructure and make sure we have a criminal law that will define and sanction every possible crime. So that's just the short answer to the question you posed, and I hope that answers your question.
Thank you so much, Mr. Benedict.
Mr. Abang here.
No, before you respond, most questions came out from Chinelo's
I have
presentation.
quite a lot of issues, sir, to deal with that.
No, I would like to want to say one or two things quickly, so that when Mr. Kayode is responding, we might not need to come back to her again and go back to. So let her quickly.
I think first was the issue raised by the Learned Silk on multiplicity of actions and simultaneous civil and criminal proceedings. I think that was addressed, I think paragraph 16 of my paper, where I addressed that issue and explained how improper and how that limits human rights. But going further, I think a lot of things came up from the very well articulated presentation by the ICPC. And I will say that there are some takeaways. I made a lot of notes. And first is the issue where you mentioned that some administrative steps are being taken, committees have been set up, And in my humble view, this is my suggestion now, a recommendation, that we should not leave these things as administrative measure. Continues. Government is a or traced to particular office. Then secondly is that these monies are being paid to CBN by administrative fiat. I don't think this is proper too. The CBN is not a party to the action in court, if we remember. And if in the event that my property, my cash is taken away, and then by administrative fiat is paid into the CBN account, and then I get judgment, and I come back, I'm coming back to EFCC or the ICPC, and then what happens when the ICPC goes to the CBN and something has happened to the money? I can't sue CBN because CBN was not a party to the action. The court never made an order for the money to be paid to the CBN. Therefore, if we have that kind of arrangement, then it's for the agencies, the applicants in court, to now make CBN a party to every application, so that, and provide the account number, the particular account in CBN, so that when the order of court is made, the order is made directing that money be paid directly into that particular account. I think that was what I meant, paragraph 28 of my paper, where I said designated by the court, an account designated by the court, so that in the event that that order is to be lifted, it is lifted and an order is made straight to the CBN to give me back my money, so that I don't have to sue anybody again after that court action. And then the other reason is that you find there are situations, I know one, where properties were seized from a person, money was also collected, this money running in hundreds of thousands of dollars, and no mention of forfeiture was made of that money. The other properties were forfeited, matters are still in court, but that particular money was not mentioned anywhere as having been forfeited. Now there is no court order, there is no record of it anywhere. So if you don't have that record in court, how are you sure that that money is with the CBN? So if there is no central registry for the court, and there is no law made criminalizing officers who refuse to bring any amount received by them to the notice of the court, monies will continue to miss. And that's why we have the situation where the Ministry of Finance comes to say, this is the amount of money we have. EFCC says, no, this is the amount of money we have. The other party is saying, no, that's the amount of money we have. And then there are just conflicting information here and there. So we need to have a streamlined and central database where every information goes in, and anybody who wants to access this information can access it immediately and without conflicting information. Thank you.
Thank you, Chinelo. Mr. Abam, quickly respond to the questions before Kayode will finalize it.
Okay, distinguished Senator, you asked questions as to how to get value for our youths, basically. Yes, we understand that unemployment, poverty, and maybe the get-rich-quick syndrome is part of what is driving the wave of cybercrime we have now. From a government perspective, the NCC has done quite a lot in investing in communities, in schools, in institutions, and even in people to make them have a feel of what ICT is, to also make them have an opportunity to show their ideas, to showcase their ideas. We have, through our Universal Service Provision arm, we have what we call an annual hackathon. It's a program where youths are selected across the states. They're given an opportunity to come up with original ideas. And when at the conception stage, when there's potential in that idea, you find that there are funds to help use those innovations to produce prototypes. And some of them initiatives. From some of these initiatives, you have some apps coming out, and these apps are then able, interested investors are able to invest in those apps, either privately with the teams or in consonance with government, to their benefit. So that's one way to encourage youths to participate in a process that helps them to become independent as well as being innovators financially. Then you also have a situation where we have setting up of technology hubs. You have a lot of them being individually driven. Some of them are driven by maybe the developers of certain platforms. Like you have Jack Dorsey of Twitter. He's always in Nigeria trying to encourage those smart tech hubs for youths to be able to at least bring up innovative solutions to society's problems. We have looked at setting up those tech hubs directly by ourselves, but to a large extent, what we do is we incentivize private IT groups to set up some of these hubs so that youths can come in and find a way to develop new solutions to problems we have in society. Then we have direct investments in schools. For example, in secondary schools, we have the school access program. So we will come to maybe a community, probably through the National Assembly or through the governor's office or wherever. They indicate, okay, this school this year. Might even or advanced digital appreciation programs for tertiary institutions and all of that. There's so many of them that we run. Then we do direct supply of, or rather direct investment in law enforcement agencies sometimes, like police commands across the country. We have given many sector side. All the industry some of them are and learn how to develop apps and we have that with all the other operators. Data management and harmonization, which we were talking about. Yes, steps have been taken to harmonize. One of the biggest problems we have is the criteria for data collection. It evolves in a cyclical manner. Today you have the country talking about a national ID card project with several criteria for registration, and then they abandon it halfway, maybe because of change of government or some other thing. And the next cycle you have, the parameters are shifting. So we have a situation where NIMSI is saying, I want a 10-finger biometric capture. But some others are using the thumb, just the 2 thumbs and the 4 fingers. So you find that there are gaps in information. We need to first agree as a country, what is the standard you want? And then, anywhere where the information is not complete, if I have registered with the immigration services, maybe I have a passport, and maybe I did 4 fingers, and I then did 10 fingers with NIMSI for my national identity, just cross-match the data. Cross-match the data and scrub the data so that you can then eliminate, if you have to have ways of ensuring that this data is from the same person, find a way to set the criteria so that you can eliminate duplication. And then you have one clean national database, which is like a foundation stone. Without it, we are going nowhere as a country. That one is a fact. Then the issue of The questions you asked, my dear. Yeah? Okay, yes, the issue of drop calls. Ren, that I understand the entire literature. The truth is this. I know that the experience is not perfect. So I'm not standing here to say the experience is perfect. Even abroad, although the margins are smaller, you still have some of these things happening. But that's no excuse. Truth is, you have a situation where we have developed over a period to get services that before 2000 and 2001, in fact, would have been hell to get an access to a line. So you find that capacity is a major problem. You also have issues of these same gaps in infrastructure and information infrastructure. Basically, you have those gaps. So sometimes I can tell you why a drop call can occur in a certain area. I'm making a call. The operators prioritize their investment, and that's the truth. I can't go and put equipment worth 500 million in a location where I have only maybe 100 people. Do you understand? Revenue, that's my revenue projections will fall flat. And I'm not into the business for the sake of being a, what do you call it? Someone like who's just like government, spending without exactly knowing where I am. It's a commercial thing. Do you understand? But we have what we call quality of service obligations. We also have what we call grade of service standards. So they know the standards that they should meet up with. There are also situations where somebody makes a call and the call is dropped. You know, sometimes the reason is because at the relay point where the towers are relaying the information, vandalization has occurred at one of those towers. I remember I went somewhere in Udobolu, then I was based in the Lagos office, because MTN suddenly went down in the whole of the southwest. And the report got to the president. The president called our CEO and it became a problem. So I had to rush to Udobolu in Ogun State to check the situation. I found out that the community association and the chiefs and all of that were unhappy that a particular base station, MTN had come to change generators and all of that. It looked like something good was happening there, and they were not being given any cut in the process. So what did they do? They went and got their local juju and put a barricade in front of the access route to the tower and said anybody that crosses it, all manner of evil things will happen to that person. Of course, people fear for their lives. So the engineers were afraid to go there. The diesel ran down and the whole place shut down. Now, not every tower is the same. Some towers are just relay towers. Some towers are what you call hub sites. They're like a master site that carries a lot of equipment and information. Some of them can control as much as 200 sites. If you let that one go down, bye-bye to those 200. For the period that one is down, those 200 will not relay any signal to you. It's a hopping situation from here to here to here like that. It's a cellular situation. So these are some of the issues. Some people go and dig up fiber cables. They're expensive. They are made of glass tubes. They dig them up, and because there's a ready criminal market for people to buy those things, they dig it and they cut the cable and go and sell it. Of course, the signals will not jump the gap. That's a problem. You also have a situation where state governments, and this is state government, local governments, they set up multiple regulatory agencies, even where the constitution is very clear as to who has powers for communication services on the exclusive list and residual list and all of these others. You find that these guys send their touts. Some of them are like these people you see who are revenue collectors when you are traveling. They will just waylay the operators when they come to service the base stations, or they go to their office and they shut them down because they want to collect multiple tax. They will pass the law today and start effecting that law maybe tomorrow morning. Do you understand? And then even if you pay to those agencies, you find that in like maybe if somebody is impeached in government, God forbid, maybe the governor is gone or his deputy is gone, somebody, you just suddenly find that that agency will claim that the receipt you have is not one that issued from them, that they are now a different agency. I've been involved in many of these things. I've served in many parts of this country as a staff of NCC. I was a regional controller for the Southeast. What I saw there is unbelievable. I'm telling you, so many cases in court with Airtel, with EMTS with glow and all of that. And you find that the root cause is the need for IGR and greed. Just the need for IGR and greed. And then pure vandalism. So we have tried to use the Office of the National Security Advisor to protect, because of the Cybercrime Act, you know, the president can designate certain equipment as critical national infrastructure. So that's the office we are using to pursue. And then we have an MOU with the NSCDC, where they do a lot of enforcement for us, and they do prosecution because we don't have prosecutorial powers. So I'm really sorry for your experience, but that's really some of the reasons why. And then if you do have a situation where you have lost money, right, and you have evidence that you've lost money, there's a two-step process. You have every right, because you have a contract of service with your operator, you have every right to approach your operator and ask them to remedy that situation. If they don't, there is usually a complaint ticket number they must give to you. It's electronically generated. It comes to your phone. After a defined period, you should communicate with NCC. NCC has a second level intervention mechanism. We have a number called 622. It's toll free. You call that number, our people will pick up the call. They will ask you for the particulars of the case, and they will take it up. No, that's the issue. That's the issue. The issue is this. No, I need to, yeah, well, some people are petty like that. But the truth is this. Your money is your money. My money is my money. Some people will spend 500 naira to pursue 50 naira. Learn which battles to fight and which battles to let go. Even though your money shouldn't be stolen. I'll tell you, I've suffered it too, and I'm a staff of NCC. Now, if you come to the issue of possible eavesdropping, this thing you are carrying, this thing you are carrying is a machine. It's a computer. It's not just a phone, it's a computer. There are so many apps on your phone, right? And you will be surprised if you are not savvy what is running on your phone when you think it's off. There's what you call data mining. Data mining is one of the ills that the Data Protection, or maybe the Data Protection Act should cure. And the NDPR is trying to cure. Data is gold today. It's more gold than your real gold, because information is power right now. So people, even the airlines you go to book your tickets with, they mine your data. They can sell it. And it's illegal, but they can do it. Or staff who are unscrupulous can mine your data and sell it. It is wrong. The NDPR also says data, what they call them again, data controllers have obligations to you as a data subject. Do you understand? Accessing your information, manipulating the information in any way requires your consent. But databases are very important for big business, for data analytics and things like that. So people are unscrupulous, and people will mine your data and sell it for a few dollars so that they can buy the next flashy car or buy the latest handbag. It happens. In my presentation, you will find that I said that there are so many things going on that would use your data and your information with or without your consent. That one is a fact of life. So the issue is, how do you remedy, how do you mitigate? And it's starting by the database issues we have with the various agencies, the issue of a Data Protection Act, so many things we need to do as a country. Again, I'm very glad that we have a situation where we've sensed today that we have agencies of government working at cross purposes with each other. I think government needs to look at where does it want to go as a government, where does it want Nigeria to be, and how do we remove the bottlenecks that make it difficult for us to synergize and synchronize our agencies so that we can achieve worthy goals. Sorry, I'm taking so much time. Yeah, I can tell you there's a new Samsung TV. Came out like 2 years ago or so. It actually has a feature where, if you are not careful, it's listening to you, because it has a back-end system that allows it to listen to your conversation in your room and sends it to a server somewhere. Yeah, it does. I saw it. I was very alarmed when I saw that. Yo, you are so proud. But you don't even know whether it was when you are drinking Gary and within your boxer shorts that it took your pictures and your information. So sometimes the most savvy equipment you want in your house may not be your best friend. So find out. You have all of these usage policies. They are small fine print, but it's difficult, but you may need to read down to the end. For lawyers particularly, you may need to at least even once, so you know what is hidden in there. Because a lot is hidden in some of those things. Yes, I mean, that's the problem. So you have that, and it's a big problem. It's a big problem. Thank you, sir.
Thank you so much. Finally, Mr. Kayode, I know you two take sometimes, but I know you manage time.
I'll try not to. Yeah.
Thank you.
Okay, maybe I'll just take this one.
Let him take that one first. Wait first. Let him take that.
Yeah. Thank you so much, Chairman. I'm lucky that I have two questions that is just one. The question asked by the Chairman, Distinguished Editor Hosseini, and then my sister here, Mimi. You're talking about when somebody has gone to trial and then a case is not proven, what's the compensation available? I think I'll just use this to give an explanation. There's difference between investigation and prosecution. And the course of investigation is when I have to go through effective financial investigative trail and assess every evidence that I have to justify or prove an allegations or not. Now, in the course of investigation, if I find nothing, you go, no prosecution. I don't take the man to court. Like I set an example, there's a case I investigated many years ago. A chief executive of a state got his complimentary card, and then he put a note at the back of the complimentary card and gave it to the girlfriend, who took it to the commissioner. And he said, the bearer is from me, please assist. Now, this was many, many years. In the budget estimate for that particular ministry for that year, there's provision for construction of culvert, and 30 million was provided. But that it was expected to be a direct labor. When the girlfriend came with a commentary card that says the bearer is from me, please assist, the commissioner understood please assist and gave it out as a contract. No longer direct labor. She quoted for 17 million. She was paid 17 million. That's a difference of 13 million. Now, the commissioner said the chief executive, the governor, took 13 million naira from him. For me as an investigator, how? He said he collected cash. Did he sign anything? No. Who is the bearer? Bearer could be anybody. You could even pick a card on the floor and they just say bearer. By the time the lady was brought in, her statement and that of the commissioner is different. So at the end of the day, the commissioner has, look, you have federal government, you have government money in your hand, you have 30 million naira in your hand that you cannot justify how it moved away. The last known place of domicile is you. Bring it back. So in this case, the governor was not even brought in for questioning because there was no basis. Now we have situation like that. At investigation, all that are effectively sorted. We will only go to prosecution when we believe that we have a case. Like our lawyers will say, when they believe that there is a prima facie case against a person. When I also go in, I also need to use this to explain this. We've been able to understand that there are 3 stages when we are dealing with property. First one, at the commencement of investigation, we seized. At that point in time, we don't take you to court. And the investigation is expected to be within a short period of time. And that is when I talked about we can PND an account. When an account is PND, the money still stays in your own account. So if it's accruing interest, accrues interest right there in your account. I don't move the money away. If by the conclusion of that investigation I found nothing against you, all I simply write back this to the bank and I leave the restriction order and your money begins to flow again. But when I proceed and I institute a forfeiture order against money is when I believe I have a case. At that point in time, I believe there is a case. I have evidences to show that this is proceed of crime. If you win at that point, I think you are even too excited that you are discharged and acquitted than thinking of what else should have happened. Because ordinarily I must have believed I have a case. Ordinarily I must have evidences that allude to the fact that this is proceed of crime. But probably due to some technicalities in the court, or for one thing, there was a particular case recently decided, and the basis of decision in court was just the fact that the evidences tendered were not signed. And that was the basis for throwing it out. Not that the case is not justified, but on a technical ground that the evidence that were presented were not signed. So you understand? So at that instances, if you get your property back, coming back to me for compensation is even the least thing. You are lucky to go away with the property. Yes, you are lucky to go away with the property. So those are the things we need to really get this very clear. But then I must say this, and I'm sure that this will gladden the distinguished senator. If we discover in the course of investigation that a petition is frivolous, there's a section in the ICPC Act that says that for lying to an officer, section 27, that says that for lying and misleading an officer of the commission, which is what you have done, I can charge you. And I think that even carries the highest number of years in imprisonment, 10 years. So if it's proving that, look, this is just frivolous, just want to malign the man or just want to give him a bad name, right? Unlike a situation where you bring a petition and I investigate it and I find out that it's true. Now, I want to believe that that probably might have, it should answer the questions. And then for future proceeding, okay, no, the distinguished, the senior learned SIG just made a very strong explanation to us in when trial is going on in the federal high court and then you go into another court and very funny situation, but God will help us. Yes, God will help us. No, you know, for us in Nigeria, we are highly religious. So when our institutions fail, the only thing that we say is that God will help us. On this note, I plead that the chairman should just give me protection to say God will help us. Yeah, but now there's this question that comes about when we have commingling of fund. When we have fund, for us as a commission, as a practice, we try as much as possible not to seize salary account. If you look at your account, we want to separate the one that is salary. We also know that when we're looking at properties, the one in which a family lives, we always leave it unattached as a matter of practice. But then, so we try to make that separation. But then I must also say this. There are instances where if he discovers that it's that particular account that is being used as an instrument of perpetration of that crime, we could lay a hold on it initially until we are able to make a separation. And we are able to make a separation, we recover. And this is one of the beauty of the asset recovery. This is one of the beauty of the STAR initiative, Stolen Asset Recovery Initiatives. So that we can quickly recover those that is a prison. We allow you to run your account while investigations go on. But we try as much as possible to ensure that in the course of investigation, we don't make your family to suffer, so that we don't multiply criminal activities by doing so. Then I have these questions too that comes from Mr. Monday when he talks about, oh, you actually helped my case when you talk about the fact that what we need is accelerated hearing. Let this prosecution processes go on very fast, and then everybody can be effectively taken care of. And the Learned 6, Alex also helped us talking about violation of rights to privacy in the FCC. But I was happy that you said that for ICPC that I did the correct thing. And I'm happy that that is all corroborated by Paul here. Yes, so thank you so much. But then, the Learned 6 make a very strong point, which is, let us not cripple enterprise. Let's allow enterprise to flourish. And this informed the decision in the community. And I took a note here. I said ICPC somewhat has been lucky. Right from inception, it's always been aided by people from the legal profession. And so maybe that has also helped us to stabilize and then be able to build a very strong institution. There are just certain things that we do not, there are certain things that we honestly do not do. We are very, very particular. Like my current chairman Professor Bola Owasoye clearly said, SAN, yes, thank you very much. Professor Bola Owasoye, SAN, says that when you take a property that is a going concern, as a business running, and you go out there and you market, you already blacklisted that business. People do not want to transfer with it. The business goes down. He said, and we are not, what do you call this undertakers. So we must understand that we are not undertakers. The responsibility is not to go and kill the business. Now, when you kill the business, unemployment is multiplied. Tax revenue decrease. The multiplier is so much. So that is why we came up with the idea that let's bond to existing managers who have the wherewithal to ensure that the businesses continue while we go on with our investigation and prosecution procedure. Now, I must, Chinelo, my friend, Madam Chinelo, talked again about you appreciate the what we're doing now, and I agree with you that we need not leave all these things to administrative level alone. It's not in the interest of the country. And I think that should actually be one of the take-home from this meeting this afternoon. But I must also correct this, that payment to CBN is only for forfeited sum. When it is still seizure, is a restriction in the account of the respondent. So, yes, that's what I'm talking about cash now. Yes. No. We don't take physical cash. We don't take physical cash. We give you a remitter and ask you to make a transfer. If in the course of searches we found physical cash and it's retrieved, it has to be paid in immediately through remitters, and the receipt is attached to the case file. As a matter of principle, we don't deal in cash. As a matter of principle, we don't deal in cash. And that was why I was saying that based on our Act, Section 38 of the Act, that give us power to recover some to victims. And our victims vary. Federal government could be the victim if it's federal fund. State government could be the victim. I've seen cases in many instances when we have returned money to state government. Lagos state government benefited, Ondo state government, so many governments. And then the victims can be individual. And our Act gives us that power to return money to victims. And I also have this forfeiture order on I've explained that of money. Forfeiture order on properties and when money is excluded. The actual practice, best practice, like I said earlier, I want to speak for the law enforcement agency in general. Best practice is everything, every property that is attached should be listed. When you have that kind of an omission, I agree with you strongly, that's an abnormality. And as much as possible, that should not be encouraged. But then, like I said again, this is why we have this interministerial agency set up now, so that there can be a central database and all asset recovery agencies front load and furnish information about all assets in their hand. And what it said is that if it's under seizure, state. If it's under forfeiture, state. If it's interim forfeiture, state it. If it is final forfeiture, state it. If it is under seizure and it has to be returned, you simply state the reasons why it was returned and is no longer existing. If it is under interim and you loses the case and the asset revert back to the respondent, you'll be able to state, no, we lose the case for this reason, and it's reverted. And then you can also be asked a question, we found this asset on your interim forfeiture list 3 years ago. What has happened? So now for the first time, interagency, all agents responsible for asset recovery are being made to sit and talk together and made accountable for what is happening. So that at the end of the day, we won't have salami panel all over again. Thank you very much.
Thank you so much. Thank you so much. We've really dealt with the questions properly. There is one question from Facebook. You quickly ask so that we can wind up. We have so many things to do.
Sorry. Thank you, Mr. Chairman. This question, we have people also following us on Facebook, YouTube, and other platforms. So I felt it's only appropriate we take their questions too. Someone said, if the defendant sold off a third party before being arrested and tried for the offense, is it right for the security agency to still attach the property? That you are talking about the right of an innocent party, attach the property that you are talking about the right of an innocent party, because they are saying this person is saying it's still happening today. Can the security agent comment on this? That's the question.
Okay. Thank you very much. We have similar case to this presently in our hand, in which some assets were already under interim forfeiture, but you have the respondent dissipate such asset. In that case, there's already an order on that asset. The person who sold it has no right and no power to sell as at that time anymore. The person who also bought a non-existing asset, because at the end of the day, the person who gave has no power to give anymore. Yeah, but then, yes, but because, when we take back that asset, it goes back to the person that he gave his money to, and he collects his money. But then, if it is pre-seizure, if it's pre, no, we cannot go after the innocent person. We hold the man who stole the government money. We should look for how we can get government money back from him. But I'm talking about the one on which an order has already been issued. That person, he also has a responsibility of due diligence before you buy. So you fail in carrying out his due diligence. Yeah. So you bought a non-existing value.
Thank you so much, Mr. Kayode. Thank you for coming. The coordinator, Mr. Paul, Mr. Christopher, Mr. Abam, and Chinelo, and the learned participant. I didn't say learned colleagues. The learned participants. I appreciate you all. And what we've done here today, there are a lot to take home. And there is one problem that we have in this country, which is peculiar to everybody. By the time we stop that, I think the country will be good for it. We've come here, we've learned, we've heard. In most cases, what we learned here today, instead of us to take it back to our various offices, to our various institutions, and act on it immediately, we'll dump it. And I believe that those that we interacted with here today will not do same. So that at the end of the day, Nigeria can be better for it. The change that we all yearn for begins with you and me. And together we can move Nigeria forward. Thank you and God bless you all.
Please let us give the panel another resounding round of applause. We've had an educating and innovative contribution on financial crime and things related to the internet. So I want to start by just a brief vote of thanks, thanking our own distinguished senator for steering the ship and for guiding us. And in his fatherly nature, he accommodated and allowed everybody to ventilate their position. And despite his busy schedule, we even overshot the time by about 45 minutes. Thank you, distinguished senator, for giving us your precious time. And as you go back to serve the good people of Kogi Central, of which I am one, God will continue to strengthen you and guide you. Thank you very much, sir. Yes. I also want to thank the two lead presenters. They are products of the Rule of Law Development Foundation. They are staff of JB Daudu and Co. In the person of Benedict. Benedict, thank you very much. You continue to give us useful insight from year to year on the issue of cybercrime. God will continue to bless you, and don't give up on your research on this area. Hopefully, we'll soon have you have a PhD in this area. Thank you very much, Mr. Ben. Madam Chinelo, I made a prayer last year, and the prayer was answered. Everybody knows what I'm talking about. Mr. Chairman has accepted that. Chinelo, I want to thank you, not only for your work on this paper, but throughout the entire conference. You have been running around to make sure this program is a success. You have had sleepless nights. We've taken away from your home. But God will continue blessing you as we are serving not only the legal profession but humanity. So God will bless you, Chinelo. To the representative of the Director General, sorry, of the CEO of NCC, Professor UG Dambata, Mr. Abang, you stood in perfectly for him. I'm not sure if he was here would have had anything different from what you have said. You have given us even technical service and knowledge beyond the remit of the paper you were asked to deliver. And honestly, we hope you continue to join us. Next year, we will develop, I'm sure there might be legislation, there might be things that will convert these regulations you are doing to laws. And we hope to have you as part of us. And to Mr. Balogun as well, I have to appreciate you. Despite not being the only panelist that is not a legal practitioner, you are able to ventilate your views on the social media, and God will bless you. And our regards to the academia in Kogi State. I also want to thank the Director Assets Tracing, Recovery and Management of ICPC, Mr. Adedayo Kayode. Sir, you have given us a balanced conversation. Every year we've been discussing this topic, but this is, I think, one of the first year where we heard from the agencies prosecuting. And some of us began to understand their thought process, that indeed it's not that they are not trying, but sometimes they are hamstrung by a lot of militating factors that sometimes we on this side don't see. But I want to suggest, sir, if all of us can ensure everything is just written down. You know, Nigerians are, sometimes all of us can be problematic. If it's not written down in a law where all of us know how to deal with this process of assets of crime, the learned senior advocates, Mr. Kura and others have raised significant issues. There are too many lacunas and gaps in the law. So we have to look at, there are so many regulations you have all pointed out today that we are not aware of, or administrative steps you take. So I'll take home to you, sir, is that please, we also, some of us are not even aware of this. If you can make them available to us so that we can be guided in advising them. And I think that is the entire panel. If there's anybody I've forgotten, I want to thank all the eminent senior advocates here present and senior members of the profession. Those here and online, thank you for staying with us even though we exceeded your time. I know legal practitioners are very busy and we are getting towards the end of the year and Christmas. So everybody, to anybody to give you his time around this period, the person really appreciates what you are doing. So I want to thank you all and I wish you safe journey to your various destinations. We will just stay behind for a group picture. Those of us in the panel, the photographers, please organize that. Thank you very much. And we have a session tomorrow. Sorry, before I forget. Tomorrow is the last day, and we are starting as usual by 9 o'clock. And we are talking about police brutality. And I don't think we should miss this one in light of this year. This year has been all about police brutality. And I'm grateful the keynote speaker on that session is already here with us. Mr. Kura is here, and I advise you to come and listen to his paper. And he has people from the Nigerian prison services. Our chairman is Kanu Agabi. So you can see that we have a very interesting session tomorrow on police brutality. Then we have also taken note of gender-based violence. You know, we want to accommodate the gender advocates and the female activists among us. So we have a session on that, on gender-based violence later in the afternoon. So you can see we covered almost all aspects of criminal law and practice. Tomorrow is the last day, and I enjoin all of us to be here on time so that we can keep up and meet up, and so that we don't end delayed like this. So thank you all, and I wish you safe journey to your various homes. Good day.